Good morning. We're going to call our Towing, Storage, and Advisory Board to order. It is 10 o'clock. I will turn it over to Ms. Anna for a roll call. If I can remind everyone to speak your name when you're talking and mute your microphone if you are not the one speaking at the time.
Kyle Jackson, Tasha Mora,
Present.
Gary Hoffman,
Here.
Charles Rash. Oh, you're muted, sir.
Present.
And Ulmer.
Good
Here.
morning. We're going to call
Mark
our
Mitchell.
Towing, Storage, and Advisory
Here.
Board
And presiding officer Amy Milstead.
here.
You have a quorum.
Perfect. Thank you very much. All right. We were going to start off with item C, General Counsel Training. I believe our lovely Miss Elizabeth Salinas Stripmatter is going to take charge of that.
Yes,
Before we start that, if you don't mind, we wanted to introduce the new board member, Mr. Mitchell.
I'm sorry. Yes, Mr. Mitchell, thank you for joining our advisory board and giving of your time. Would you like to introduce yourself?
Sure. Thank you for having me, Amy. I am Mark Mitchell. I work with Texas Farm Bureau Insurance. I'm the state physical damage manager, housed at the home office in Waco.
Perfect. We are so glad you're here. We know this is taking some of your time, but we thank you for your expertise and your knowledge to help better our industry. And I know everyone from the state and the agency appreciates your voice as well.
Thank you.
Okay, I'll try not to skip around anymore. Now, back to Miss Elizabeth with item C, the General Counsel Training.
yes. So it's time for our I think it's every other year training that we do on various statutes that impact our advisory boards. Mr. Mitchell, since you're a new member, you will be saying this for the first time. Our current board members who've been on for a while have already had this training, but we like to do a refresher with everyone so that we're all clear on what statutes impact. We're going to be talking about open meetings, open records, walking quorums, all that good stuff that is applicable to the duties of an advisory board member, and just kind of break it down and explain to people what these things mean. So Anna will be running my slides for me today, which I very much appreciate because I'm a little technologically challenged trying to do two things at once. So as I said, we're going to be talking about our Open Meetings Act, our Administrative Procedure Act, and our Public Information Act. So the Open Meetings Act are the rules that we have to play by when we are meeting and discussing public business. The Administrative Procedure Act sets out what we do in our rulemaking process, and the Public Information Act sets out what government documents are open to the public, which, spoiler alert, most government documents are. So with that being said, we'll get to our Open Meetings Act. And the Open Meetings Act, as most of you know, the purpose is really to make sure that the public is aware of what any government entity, including TDLR, is doing at any given time. We want to be as transparent and as open as possible. So when we have meetings, they're to be open to the public, and we have to provide public notice. And public notice contains the time, place, and the subject matter of the meeting that we're talking about. So for example, today we have an agenda for this meeting. We provided public notice of the time, the place, and the subject matter of the meeting so that the public is aware, and if they want to engage and watch the meeting, they are welcome to do so. These provisions in the Open Meetings Act are mandatory, and we look at them in terms of favoring an open government to the greatest extent possible. So some of the key concepts within the Open Meetings Act are the quorum, which I mentioned a couple minutes ago. And your quorum is the majority of the members on an advisory board or a committee. And you have to have a quorum in a properly noticed open meeting in order to take any official actions. If you have less than a quorum, you can still meet as long as you've given that public notice, but the board or the committee cannot take any official actions. So in the off chance that a properly noticed board meeting was made, but something happened that morning and we could not get a quorum of members, The board and TDLR would decide whether to cancel that on the record or whether to proceed with the meeting, but no official action could actually be taken. So what do we do when we're talking about deliberating, when the board deliberates? And you'll see some deliberation happening today. All it is it's a conversation between a quorum of the board and the governmental body or another person that involves an issue that the governmental body is in charge of, so has jurisdiction of. So TDLR related business, we talk to the board and the public about what we're doing, but as long as there's a quorum, it's considered a deliberation or a discussion. And a meeting occurs anytime a quorum of the governmental body engages in deliberation, which is also discussion, regarding public business or public policy over which the governmental body has supervision or control, or any time the body takes formal action. So what we're looking at is anytime you've got a quorum of members talking about TOW BSF, a quorum of members on the board talking about TOW BSF issues that impact the industry and TDLR, you've got to properly notice that meeting. You've got to have the quorum, and in that meeting, you will engage in deliberations. So the notice I've already spoken about, just a couple of additional points. I mentioned this before, we provide notice in the form of an agenda. And how that's done is the notice is filed with the Texas Secretary of State at least 7 days before a meeting. And it has to be posted online by both TDLR and the Secretary of State. And very, very important, we may not engage in discussions about a subject that is not on the agenda. So what that means is we have a section of our meeting, which you'll see today, in which people can make public comments. If a person makes a public comment, but what they're commenting on is not on the agenda, all we can do is listen, and you all can decide whether you'd like to put that subject on a future agenda. And if you'd like to further discuss it, you would do so in a properly noticed open meeting. So sometimes it can be tempting when people are engaging in public comment with the board, but it's super important for the board to remember, you know, all we can do is listen. All we can do is take note of what they're saying. And if you decide as a quorum that you'd like to put that on the next agenda, then we're happy to do that. But really what we say is there can't be any comment during the public comment period if it's not on the agenda. So no discussion if a subject is not on the agenda, but you could put it on for a future meeting. All right, so what about social functions, conventions, and workshops? Because you all attend a lot of things for your industry. So remember that a meeting occurs whenever there's a quorum of a governmental body, which would be a board, you guys, and you engage in a discussion about an issue that's within your duties and responsibilities. And so the question is, can you ever meet in an informal setting without violating the Open Meetings Act? Yes, you can. But if there's a quorum of members and you engage in a discussion or make decisions about business or you take formal action, that is what you can't do. So at a social function, you can basically talk about things that are incidental, but you can't make any decisions, and you always have to be aware of a quorum getting together to discuss something that is within your purview. So what we say is, please don't engage. You cannot engage in substantive conversations relating to the board business or policy when a quorum is involved and you're outside of an officially noticed and scheduled meeting. The most common time for people to have issues is when they engage in a walking quorum. And a walking quorum occurs when there's fewer than a quorum of members who are talking about official business, but then they go back and they communicate to other members who were not part of the original discussion. So when there's not a quorum of members who participate in an initial communication, but there's subsequent communication that pulls in other board members, that would result in a quorum discussing official business outside of a public meeting. So let's look at an example. On a 5-member advisory board, 2 members exchange phone calls and emails expressing thoughts on an upcoming rule change and exchange research that they have each individually performed. One of the board members subsequently forwards the exchange to another member. The members have now engaged in a walking quorum because you've brought in a third person into a small group discussion outside of a properly noticed board meeting. Walking quorums can occur during conference calls, video conferences, hallway discussions, emails, text messages, social media. So what we advise is you should really never have a conversation in a public setting with other board members and then bring in additional board members, because you will engage in a walking quorum, and that's a problem. So to avoid a walking quorum, do not meet in small groups, discuss board or committee business, and then communicate those discussions to other members. Do not send emails or text messages to a quorum of members regarding official business, even if each email is addressed and sent to each member individually. It doesn't matter if the email was not a group email. What matters is the number of people that were involved in the email exchange. So do not create posts on social media about board business where it's possible that a quorum of members could exist or could participate in discussions. And do not ask a quorum of members, even on an individual basis, for feedback or for comments outside of a properly noticed board meeting. This is called polling, and it's essentially conducting an informal vote on an issue. Give me 1 second, because I kind of got a little ahead of myself on my slides. All right, so what are our guidelines for open sessions? As we talked about before, you have to limit your discussions to specific items on the agenda. During public comment, as I've said before, members of the public can speak, and the presiding officer, in this case Ms. Milstead, may set reasonable limits on the commenters. A member of the public or a member of the board, meaning yourselves, you can raise a subject that's not been included on the agenda, but the discussion is limited, as I said before, to whether you want to discuss it in a future meeting. All right, so to avoid violating the act on the basis of insufficient notice, members should, again, limit discussion to specific agenda items, avoid allowing discussions regarding specific agenda items to wander off into new issues that have not been noticed to the public. This is where we most often see issues. So we have to be very careful when we're talking that we are not introducing a new issue or a new problem into the properly noticed agenda item. We can't respond, as I said before, during public comment about things which are not on the agenda, and you should specifically identify items for future agenda items, which we always do at the end of our meetings, and communicate those to TDLR staff. So at the end of this meeting, you all as a board will discuss what you'd like to see on the agenda for the next meeting. That will be your opportunity then to, if you'd like to bring in a discussion about things in public comment, or you'd like to bring in something that a board member wants to put on the agenda, that's your time to let us know that. All right, so of course, because this is an actual statute, the Open Meetings Act, there are possible penalties for it. So what happens if you violate the Open Meetings Act? Well, any interested person, including the media, can go to the courts and say, no, they can't do this because what they did was in violation of the Open Meetings Act. And if it's determined that there was a violation of the Open Meetings Act, the action that the board took is voidable. So it goes away. It becomes not a thing that the board can do. So of course, you can also incur criminal penalties if you knowingly participate in a walking quorum or knowingly participate in a meeting that is closed to the subject, and there are misdemeanor criminal penalties attached. Those penalties are a fine of $100 to $500, confinement in county jail for 1 to 6 months, or both a fine and jail time. So I think we have sufficiently discussed how we avoid and what our best practices are, how we avoid violating the act. But if you'd like additional information on open meetings, we've given you some resources here that you can go and read more about open meetings. Of course, you're more than welcome to contact me. And if you have any questions about open meetings, happy to discuss that with you. So we're going to move on now to the Administrative Procedure Act, which is also known as the APA. And the purpose of that, as I said a few minutes ago, is to establish uniform standards for state agencies for practices and procedures, and to provide for public participation and transparency during the rulemaking process. So what is the definition of a rule? A rule is a statement made by a state agency that implements, interprets, or prescribes law or policy, or describes the procedure or practice requirements of a state agency. So in the TOW VSF world, we have a statute, the TOW statute, that says you guys make rules, and the VSF applicable statute. The commission is allowed to make rules that are applicable to the program. So you have the statute, which is the law, and then you have the actual rules, which basically, the way I explain this to people is tells you how the program is going to run, has specific things about licensing, specific things about prohibited acts, further fleshes out the statute to give you a framework under which licensees work. All right, so how does the APA define a rule? A rule excludes a statement regarding only the internal management organization of an agency and not affecting private rights or procedures. A rule includes a new rule, an amendment to an existing rule, and repeal of an existing rule. Sources for rulemaking come from a lot of different places: the legislature, you guys, the advisory boards, us as TDLR staff, the 4-year rule review, and a rule petition. A rule petition is when a person, any person in the public, submits a prospective rule that they want adopted by the agency. An interested person has to be a Texas resident, a business entity located in Texas, a governmental subdivision in Texas, or a public or private organization that is not a state agency but is located in Texas. So any citizen in the state of Texas essentially can come to the department and say, I want you to make a rule on this. And then we are required to look at that rule. But also, we as an agency can initiate rulemaking based off legislative mandates, based on our 4-year rule review, the things that I talked about a couple minutes ago. So let's look at the rulemaking process. And I think this slide is very, very important. And the reason why I think it's important is because I think there's a lot of misunderstanding about what the rulemaking process actually entails. The rulemaking process is extraordinarily involved. Within the department, you will always have myself involved, regulatory program management will always be involved, and any of our other divisions, licensing could be involved. Any of the other divisions that we think need to be involved in the rulemaking process. So you will have multiple staff members. And then we also have rulemaking coordinators who work with us on the rules. And then we also have input from our executive management on the rules. And we have input from the board, and we have input from the public. And all of those things take time. So when we are working on rules, sort of what we do is we work with the rules coordinator to ensure that if there are statutorily mandated deadlines attached to a specific rulemaking, that we are hitting those deadlines. Generally, rulemaking, depending on the rule, can take anywhere from approximately 6 months to a year, possibly even longer. And why is that? It's because we have to go through all of these steps here that you see in this chart. And all of those steps are necessary and prescribed for us to go through them to ensure that the rulemaking is both transparent, open, and that the rulemaking at the end of the day is the right rule for the program that's in line with the applicable law. So rulemaking isn't something that we sort of just decide one day, okay, we need a rule on this, and then we can, turn around on a dime and do it. It takes months and a lot of people involved and a lot of labor to create a rule. So by the time we get to you all to present the rule, there have been a lot of people involved, a lot of time and a lot of resources to ensure that what we are presenting to you is within the parameters of the applicable statute, that it's been appropriately reviewed, and that it is something that is both necessary and or required for the program in order for our licensees to remain within the statutory framework of the program. So here we go on the rule review process. Programs that are on a 4-year schedule, that's our 4-year rule review. That happens every 4 year. The one for this one is coming up. I'll have to check on the date with our rules coordinators, but that one will be coming up in the near future. So you all will be able to participate in that, and we will put out a notice of intent to review. The public will have 30 days to comment. I will review the comments, and Mark Gladney, who's also a GC on this program, will make recommendations to the commission on whether to adopt the rules as currently written. And then we will look at whether we need to make amendments to the rules, repeal any rules, add any rules. So the first step in the 4-year rule review is really just determining whether we need to adopt the rules again as they're written. And then we go back and we will make specific changes. So in the 4-year rule review, that's another very lengthy process that we go through to ensure that our rules are necessary and or required for the running of the program and for our licensees. So rulemaking, we gave you some more resources in case you'd like to look at that. Or again, if you have any questions, please feel free to let me know. You can let me know during this meeting when I conclude my presentation, or later on if you'd like to contact me for additional information. I'm happy to meet with you. All right, so now we're going to talk about the Public Information Act. And the most important thing to know about the PIA is that the PIA gives great latitude to the public in terms of the information that they receive about the workings of a government body. So it allows the public to access information about what we're working on, what our official acts are. And so it makes, with some exceptions, all documents, records, and other information relating to official business open to the public. This includes emails. This includes text messages. This includes any form of a document in which public business has been discussed. And as I said, there are some exceptions, but you should always presume and assume that anything you put in writing in relation to advisory board business is an open record. All right, so public information includes, and this is super important, electronic communication from any device if it is in connection with official agency business. What does that mean? So you all do not have agency issued cell phones, but I presume all or most of you have your own cell phones, your own tablets, your own computers. If you are discussing agency business on those devices, the communications created on those devices are subject to the Public Information Act. So we could ask you to produce those communications at any time. And as it says here, the act should be liberally construed in favor of granting requests for information. That being said, we do carefully look at the information that's requested to determine if any exemptions apply. And our open records attorney will seek OAG opinions if necessary, if there's a dispute over whether a document is or isn't open to the public. We have someone within the agency whose job it is to figure that out. And we love her. Her name is Mia Settle. She's been here a long time, and she's been in the open records world for decades. And so she will carefully look at these requests for information to ensure that we are releasing as much as we can, but we're not releasing anything that is exempted under the act. So if you as a board member receive a written request for records or correspondence that looks like a public information request, you need to go ahead and forward that to the open records team ASAP. You can forward it to me, but also forward it to them. And if the GC for the open records team, who I said before is Mia Settle, contacts you and needs information, we need for you to respond to her as soon as possible. We must respond to requests no later than 10 business days after receiving the request. And super, super important, we cannot ask why someone wants records. We can only ask for clarifications through the open records team. So if a member of the public contacts you all and says, I want the records for X, then you would forward that immediately to us. We would look at it and we would be responsible for responding to questions. There is a presumption of openness. Some of the examples include to protect highly private information, dates of birth, most email addresses, driver's licenses, license plates, and VIN records, credit card numbers, information that is designated as HIPAA related information, or that is protected in the Texas Medical Records Privacy Act. So as I said, Mia and her team go very carefully through a request to determine whether we have responsive documents. If we have responsive documents, those documents then go through a layer of review to redact out any information that the Act provides an exemption for. And so highly personal information, the state legislature has said does not need to be released. So we will redact that out prior to providing those records to the public. All right, so again, we've provided you with some resources. That concludes my training on this particular matter. If you have any questions, I'm happy to take those questions now, or you can catch up with me later. So I will open it up to the board to see if any of you have any questions. Madam Chair, if you'd like to take over from here.
Board members, do you have any questions for Miss Elizabeth right now? Okay, Elizabeth, thank you so much. You always do such a thorough job in keeping us on our toes and making sure we follow the rules, and we need that reminder ever so often. Okay, next we're going to go to the approval of minutes. I believe all of you got the minutes from Anna after our last meeting. We're going to need to make a motion to pass those minutes.
Ken Ulmer makes a motion to approve the minutes.
Gary Hoffman, second.
We have a motion and a second. Okay, Ms. Anna, do you want to do a roll call to make sure we have a motion to pass?
Yes, ma'am. Tasha Mora
Here.
is to approve, so yes.
Sorry, I was a little distracted. So I do need some guidance. I think there's just a small area of the minutes that I had a question about, and I don't know if this is where we would need to clarify that.
Well, we have a motion on the floor, so that needs to be either approved or denied. Well, we could do a discussion on that and then edit the motion, if that's what you'd like.
Can Ken withdraw his motion?
Yes.
I will withdraw my motion to allow some discussion on the minutes.
Okay.
Okay. So it's a small detail that I'm seeing, and perhaps I'm just not remembering this accurately, but third paragraph or third line from the end of our minutes. Let's see, it says an update on the VSF 11 form, how it's functioning, and the tow to the next agenda. I wasn't sure what that was.
Okay.
And the tow to the next agenda, and it could have just been a typo. I'm not sure.
Let me pull it up for y'all so everybody can see it.
Okay.
Okay, is everybody able to see that?
Yes.
We can see your screen, and I think it's the bottom of that page. There we are.
Oh, okay, so here. This just needs some clarification then.
That was the only area that I saw. I didn't really quite understand what that was, and I didn't want to just. Perhaps it was just a typo.
Table this until the next advisory board meeting. I'll go back to the video of last meeting and edit that and then we can approve both that one and this one at the next meeting, if that's what you'd like, Ms. Milstead.
Any problem with that as far as board members are concerned?
I don't have a problem with it, but I'm almost positive, obviously we want to verify that that was going to be a discussion on the new VSF form.
That's what I was gonna say. It should
And
say,
that's on the agenda.
It should say VSF Form 12, not Form 11.
Okay, so we would need to make those adjustments to the minutes on it and then we'll approve the next meeting.
Yeah, sounds good.
Thank you.
Okay, okay.
Mhm,
Thank you,
thank
Ken,
you.
for withdrawing your motion. Tasha, thank you for catching that.
Sure.
Okay, that's gonna take us to item agenda E. That will be public comment. I'd like to make this statement that any person wishing to address the board must submit an email by the following to the public comment instructions found on the last page of the agenda. Emails must be submitted to the board liaison by noon on Wednesday prior to the meeting on August 2nd. So that's what the rules were on this. We did receive 2 public comments. One, I believe you all received the packet on Edge, I think it was, for your case to review. And then we can bring that up and add it to the agenda if that's something we feel we need to discuss at the next advisory board meeting. Any questions on that? Okay, the second public.
Ms. Milstead,
Uh-huh.
sorry, the Castilian Strip Manor General Counsel. On that one, I looked real carefully at it, just y'all decide what you want to do with it, but I am construing that comment as a sales pitch. So please keep that in mind. Agenda or not.
Yeah, everyone's shaking their head. We got all of those pages as that.
So that was kind of where my question came in. Do we just accept anything that someone submits? Or would we say this is more of a sales pitch and it's not something that the board would, or do we just allow anyone to submit anything that they like?
They can submit anything that they'd like, and you all have discretion whether to ever talk about it. You don't have to. And so sometimes we just take written comments or public comments in, we listen to them, and then there's no action ever taken on it. So they can come in, do what they want to do, and then you all have the ultimate authority to decide whether it's really something you want to discuss.
Thank you for the clarification.
Okay. Our second public comment is from Mr. Trevor Forbes, and I think he's going to join. Is that correct, Anna?
Yes, ma'am, he's joining now.
Ever talk about it.
Mr.
You don't.
Forbes, if you could pause your YouTube. Okay. Mr. Forbes, can you hear me okay? You're muted, sir.
Yes, I can. Really tough.
Okay. Trevor, thank you for your public comment. I have a couple of instructions before we begin your presentation. I want to thank you for being here. When you begin speaking, make sure and repeat your name for the recordings as well, and who you represent. You're going to have 3 minutes to speak to the board. Please understand board members are not allowed to ask any questions or discuss anything that you're going to be talking about today. If it's not on the agenda, we cannot discuss with you. Do you understand all these instructions? I see the thumbs up. Okay, please proceed. You have 3 minutes. Thank you for your public comment. I have a couple of instructions.
Mr. Forbes, if you could pause that YouTube that you're following along to the YouTube, there you go. Yes, I think you understand now. And then unmute your, there you go.
Okay, I was trying to figure out who was talking. It was hard, and it was my fault.
It's okay. Anytime you're ready, sir.
Okay, Trevor Forbes, I'm the CEO of Summit Vehicle Solutions. I'm here representing Southwest Tow Operators. I will be very brief. We submitted the proposal that I hope you had a chance to read. Effectively, we believe in 2021, the rate adjustments that were conducted per the statute were done slightly differently than they had previously and slightly different than is outlined in the statute, which caused a decrease in our storage and impound rates of about 42 cents. While I know that doesn't sound like a lot, our businesses are very low margin, very high CapEx businesses, and those small changes make a huge difference, especially compounded over time, and especially in light of recent inflationary events. So our proposal is effectively to ask TDLR in this upcoming rate adjustment rulemaking to basically do a catch up, to effectively utilize what should have been the rates in place on December 31st, 2022, what should have been, and then apply the adjustment to that rate as opposed to the rate that was actually in place on December 31st, 2022, which was compressed artificially by about 42 cents. So a pretty straightforward request, although I'll admit the math is not as straightforward as it might sound. It hurts my brain a little bit to mess with it. But we would very much appreciate TDLR taking that into consideration during this next rate adjustment period.
Thank you, Mr. Forbes. We appreciate your comment, and we'll let the board make decisions on that later.
Okay,
Thank you.
awesome. Thank you.
Okay. I believe we're going to proceed to item F. That would be staff reports. I'd like to call on Laura Hernandez for the licensing division.
Good morning, board members. My name is Laura Hernandez. I'm one of the licensing managers in the licensing division, and I am the manager of the tools team. I submitted our statistics for fiscal year 2022 and then the first 3 quarters of 2023. As you can see, the numbers for the population percentages online have not changed much since the last time I reported numbers. You'll have the numbers here for all the tow companies, individuals, the trucks, and then the vehicle storage facilities and the vehicle storage facility employees. The active tow companies by license type or as of the date listed on my report that I submitted the report. And so you can see that date. I don't know if anybody has any questions on these statistics. I'm happy to answer any questions on those.
Board members, any questions for Laura? Now would be your time.
And then underneath those statistics are our current projects. We're still gathering the number of emails that we receive from customers because the licensing team handles all the emails and web contacts that come in from the public. And so we're still working on getting a process of how to get an accurate count of how many emails we are receiving from the industry. You can see right now it's still a manual process, but we are working with other divisions to find out how we can get a more accurate count. But you can see these are the email counts for fiscal year 2023 through June.
Okay. Any questions for Laura?
Could I just ask a quick question about the online renewal?
Sure.
I noticed those numbers are pretty consistent,
Mhm.
consistently high, which I'm very happy about. Are those accurate numbers that it's really 99%? So almost all of them are being renewed online?
That's correct. Almost. We rarely receive paper when it comes to either tow companies and individual operators. All of those are pretty much done online, so we don't even really need to touch those. The only ones we do touch are the tow companies, but we do have to start that beginning process when the company can go online. That system is interactive, so the customer can go in and actually go in and see their status, and we don't have to do anything on our part to get those licenses issued. But yeah, those are accurate.
So if you look at vehicle storage facilities, the percentage of renewals online for those are less. So we're like 9% less.
Those are a little bit less. We do get a little bit more for vehicle storage facilities, but not that many. It's a smaller population. So, but
That's true.
that's why we just tend to get more of those, and the vehicle storage facilities like the paper. Not really sure why that's different than tow companies, but it's still very minimal, even for work for us as far as paper.
And I want to commend TDLR for that. I think that is awesome. I do all of our stuff online and it really works very well. And I can't say enough good about it. I wish more governmental agencies would do that. Regulations would be an awesome idea for commercial vehicles. So yeah, I want to commend y'all for that. Great job.
Thank you.
And I have a question as well. And I'll echo, there's Tasha Mora. what Ken said. This is just great to hear that everything seems to be online, how many licenses are being renewed. I know that perhaps, and I was listening to the commission meeting this week, and so there was some discussion of that. So it's really great to see for VSF and tow specifically that it seems the process is primarily electronic. The industry licensees are depending on it being filed electronic. There's the approval rate is great. Is the department experiencing any lag time with the tow or VSF renewals or issuing of the licenses, or there's a pretty understandable turnaround time?
Right, that's the turnaround time for those. There is no backlog.
That's
Those are one of our easier applications to process. So, and the whole entire team can process those applications. Those are easily. So there's not a backlog for tow or VSF.
nice. Okay, thank you.
Any other questions for Laura? Okay, Laura, thank you for your thorough report. We always look forward to hearing the numbers. Thank you for what you're doing in your department. We appreciate it.
Thank you.
Okay, that takes us to Education and Examination Division. Michael Strawn, I think it's your turn.
Good morning, Chair and members. My name is Michael Strawn. I'm a manager for our Education Examination Division. Here to provide you our statistics today. Hopefully y'all can see them a little bit better on your screen than I can. It's a little fuzzy for me, but in general, for our continuing education courses, we have remained very much in line with where we've seen in prior fiscal years. Same thing with our training programs. We've held absolutely steady with 8 across the board on the total training program curriculums that are available. And moving down to the last part of our report here, education has a very small part in the tow industry is our CE monthly invoices. You can see kind of what we've collected for each month, and we remain pretty steady on those collection rates and fees owed to us at that rate. That being said, that concludes my report, and I'm open to any questions you all might have.
Michael, Ken Ulmer, quick question. The fees, are those the fees per student that are submitted to TDLR?
I believe so. I can get a full answer for you on exactly what all these fees encompass. It's done in another section, another area, but I can certainly get that to you.
I was assuming that's what it was. I mean, I'm making the guess that that's what it is, because I guess it would also be the fee to renew the CE training curriculum also, right? Or is that done somewhere else?
That's in a different area. This should be the students' report. I just want to double check that before I tell you absolutely. But yes, the fees for renewal are that's not something we would capture here on this area. That's done when you're applying or renewing that provider.
Yeah, I don't see anything wrong with it. I was just confirming that that's what it was. I thought that it was. Thank you very much.
Yes, sir. Thank you.
Any other questions? Okay, Mr. Strawn, thank you for your report. We appreciate it. All right, that takes us to Customer Service Division. I believe Myra Rodriguez will be delivering the report today.
Good morning, board members and TDLR staff. My name is Myra Rodriguez, and I am filling in for Claudia Enriquez, the manager for this program. So as you can see here on the screen, our fiscal year 23 contacts in comparison to the 2022 show a slight decrease for this current fiscal year. We have taken a peek in the month of March for 2,252 total contacts for this fiscal year. But overall, it is a slight decrease in comparison to fiscal year 2022. Other than these statistics, I'll be happy to take any questions for you.
Quick question, and I think we've probably asked this before. The number of emails is really low and it's mostly calls. Is that true? Or I think that was a skewed number, right? Or I know we've discussed it.
For customer service, we do answer some emails. So as Laura mentioned earlier, her team started taking emails that include paperwork, like attachments for the license and the renewals. Our team takes general questions, so that's why our email count is so much lower than Laura's.
Okay. Is it pretty readily understandable if someone has just a general question like, hey, how do I do this? Or, a TOA or a VSF business, is that in other words, is the access out there for people to be able to understand they can send that via email? Because in my opinion, it would be much better for them to have it in. Is that something they're really accessible? An email to ask a question?
It is. Yeah, it's the same with all of our programs across the board. There is a contact page, and they just select what program they're calling about, so it would get to the right team.
Okay. Thank you.
Question, this is Tasha Mora. I noticed that in June of 23 compared to June of 22, there's a pretty significant decrease, which I don't know if that's a good thing or a bad thing, but 21% lower. Is there any ideas why there might have been just such a noticeable decrease there? I'm glad that the workload isn't there. Perhaps the industry is getting their questions answered. I did notice that was a pretty big drop. Was there any ideas why the drop might have occurred?
I don't have a specific answer
Okay.
to your questions as far as like why that would be at this current point in time, but it's definitely a good thing for us. We do try to offer a lot of support, online, and they do, as Laura mentioned, submit most of their, renewals and applications online, but I don't have a straight, I guess, answer for that.
Yeah.
It just looks like it's a trend overall for the year. It's just slightly lower.
Good for workload, I would imagine. It's
Yes.
you can get some relief there. Okay, thank you.
Sure. Board members, any more questions? Okay.
I would
Myra,
think too, just one quick statement, Ken Ulmer. I would think too, because I mean, it is a pretty substantial decrease across the board, with the exception of 1 month. Do you think that's possibly some of this outreach by TDLR and Todd Forrester and things like that to get information out to people? Could that be part of, I mean, I'm sure it's a multitude of things, but
It could be, and I would let Todd, answer that if that's more in his area for the outreach of that. But yeah, it is across the board. It's great, like I said, for us, but it could very well be, more for Todd's area.
yeah, I can't see it being a bad issue any way you look at it. I think it's good across the
Right.
board. Obviously, the industry is getting better understanding,
yes.
or they would be asking more questions. So
I agree.
great, thank you.
I agree with that. I feel like they're getting better educated, and I think Todd's probably doing a fabulous job, him and his team. And I'd like to know how much direct contact they have with him, if that's cut down on the customer service department, and he's taken the other side of that.
He is extremely helpful when it comes to answering those technical questions that we can't handle here, and so he's great.
Todd, are you with us right now?
I am. I wasn't sure if it was. It's not technically my turn, so I didn't want to butt in. I will definitely take full credit for it if that's what's being offered. I do handle a lot from customer service, but also from previous contacts from customer service. So customer service will contact me. My phone number and my email are always in the reply. I welcome people contacting me with any questions. We are still continuing the training, which I'm going to talk about later. But it is kind of an ongoing thing. Getting to better know the industry, know the players in the industry, opens up opportunities for them to contact me directly. That could save everybody a lot of time, customer service, the industry from not having to go through various people. And I can usually get them the question pretty quick via email or phone or even text message. I take them. So I think it's a combination of all things. Customer service does do a great job, but they have a lot on their plate. And I thank them a lot. And, I help wherever I can. And I hope it's helping.
It is. I
Tasha
appreciate it.
Moore.
Yeah.
I do have and I don't know if there's an answer, but I just want to at least, I see a connection here, and perhaps the department's already working on this, or the two departments are working on this. So monitoring what the pattern is of the phone calls and requests that are coming in and the trends for the customer service line to see if there's a higher volume in one topic or the other. And then making sure that whether it's the website or with Todd's work and such, that there's an area that's easy to find for licensees to go find the information. Because right now they're initiating all these calls, and it might bring that volume down. And I would think as a licensee, you know, if you could find it easier, or maybe it's just it's not there as visible, it would lower the call volume down. But I was just wondering if there's any connection with what's going on in customer service of watching the patterns and then deciding, oh, there seems to be a pattern here, and let's make sure that information is made readily available on the website or on the emails and such.
I can tell you that for customer service, the top two reasons that they call in about is for license statuses and consumer complaints. So, you know, that is the top two reasons that we receive phone calls here. Now, with the license statuses, it could be, you know, something like, hey, I applied yesterday, or they do go on pretty quick, and they have a really good system for the companies and the individual licenses. But sometimes they just have questions with their license status. And so that is the bulk of our calls.
That makes sense. Okay.
Mhm.
Thank you for that.
Sure.
Sorry, I'm talking to myself over here. If there's no more questions from the board, thank you, Ms. Myra. We appreciate all your report and answering all of our questions.
Sure, no problem.
Okay, that takes us to the Enforcement Division. Natalie Oliveira.
Good morning, advisory board members. My name is Natalie Olvera. I'm a prosecutor in the Enforcement Division, and I'll be presenting enforcement's report to you today. First, we have the statistics of June of fiscal year 2023. There's a slight typo in the heading that states 2022 instead of 2023, but all the statistics are correct. Of the tow and enforcement cases closed, approximately 6% and 10% of those respective cases have resulted in disciplinary action, which would include commission orders, default orders, and agreed orders. These numbers are a slight decrease from previous reports, but they are staying closely on trend with past statistics. For case highlights, 2 cases have been added to your packet to provide examples of complaint cases resolved by the department. And that's all for enforcement's report, and I'm available if you have any questions.
I, Tasha Mora, do have some questions, and I have a broader question. If any of the advisory board has, or the advisory board might have recommendations for the data that's in this enforcement report, or perhaps a format of this report, and would like to discuss that. I know we don't want to belabor that in an actual advisory board meeting. Is that something that the department would be open to? And what window does a person go to for that? The data, there's a lot of data here. Now that I'm learning how to consume much of this information, I still have questions. And I think that it would be really good to be able to have the report, be able to answer those questions, so we're not picking it apart in an advisory board meeting. So any thoughts to that?
So Elizabeth Salinas, Strip Manor General Counsel. So the conversation that you're wanting to have is the type of conversation that we need to have in an open meeting.
Okay, good.
So if you want a full discussion, this would be the time to do that, or you can start doing that next time so that our enforcement prosecutors are aware that you're going to be asking specifics about statistics, because I don't know if they'd be able to answer your questions today. I'll
Understood.
tell you, Natalie is one of our best prosecutors, and I have full faith that she can answer your question. But your questions may delve into some aggregation of data that she would need time to look into.
100% understand. Then so that we keep with the open records and open meeting, I see the numbers that are currently there. So I see that the report is showing that the total complaints received. Let me back up and say, I'm not going to have questions about the specifics of these complaints. It's more the number. I'm looking for some additional data there. So the total complaints that were received looks to be 6,575 for tow. I'm just going to use tow as an example. And I see that the new cases was 1,022. I see a case is closed, and if I go further down to cases pending, there's 946 cases that were closed, but 841 that are pending. So that math actually comes out to 1,787 rather than the 1,022. So what I was seeing is that we have the total number of complaints that was received during the period, so January through June. We also have the total number of cases that were opened January through June. But what we're missing is the cases that were already open. There's 665 cases that look like prior to January 2023 might have still been open. Because it absolutely kind of used some of these statistics. So we have, it just makes the math is just not adding up. And I'm looking at, of the cases that were closed, it's a great number. Those that were resolved within 6 months, 48%. But were those cases that were opened in 2023, or is that including cases that were still open for 2022? Because it sounds like we still have a lot of cases from 2022 that are still open, if I'm doing the math on this correct. And I mean, I try to make sure that I didn't muddy any water, but I was trying to track here, and I just saw that the math wasn't adding up. So it looks like we've got some cases that were open in 2022 that are not accounted for. They're kind of buried in the math here.
Well, what I can tell you, this is Natalie Olvera, again, with enforcement. Some of these numbers, like you said, do include cases that have been previously opened, and some of them do take a little bit longer to close because we really try to work with respondents to come to amicable conclusions for every party involved. And then, again, that takes time. But if there are certain questions or data that you would like how that specific statistic came about, we can get that to you.
Okay. And so I would appreciate it. And if I'm reading this, the total complaints that was received is for tow, 6,575. And the number that was closed was, let me back up. The number of complaints that was received, that's the other number I'm looking for, Natalie, is, okay, the number of complaints that was received was 6,575. And then of those, if I drop down to the tow column, the cases that were opened was 1,022. So it looks like 15% of the cases were opened. And 85% were not opened. If I'm running the math on there, and I would like for the report to be able to reflect that, okay, there's a quantifiable amount, and of that quantifiable amount, the total complaints that was received, a percentage and a number, which the numbers here were opened, but we don't have the number of the cases that were not open. And I think that that's valuable information because that's still a lot of workload and legwork that the department's receiving these complaints, and 85% were not opened. And I know there's a vetting procedure for that as well, but I think that's a valuable number to know that that's a huge number of cases that the department has determined that they're not going to open a case on this. That's And why is it? Perhaps is there not a violation, or is there not jurisdiction, or such? But that speaks, in my mind, volumes for the licensees. That's a lot of cases that didn't even pass the first or second round to be investigated or even opened. And I believe that the industry should get credit for that, per se, to be able to show how is the industry doing.
Sure. Well, I can say to that, of course, the number of complaints that you've received, 6,500, and the cases that have opened are about, 1,000. So, of course, all the complaints like you referenced, they do get vetted. So if they don't meet the standards or the criteria that we have requirements for to open a case, then the case is not going to get opened. But you are correct. There are quite a few complaints that are received, and they do not become cases for different reasons. But all those reasons are going to encompass that they don't, meet the criteria to open a case, and a lot of the complaints opened are due to criminal history reviews. Um, so again, those are not going to be cases if we decide, we are going to, issue somebody a license and clear that case.
Thank you. And that was another question that I had, was a criminal history records review. Those are complaints that do not come from a consumer, do not come from the department. Where do these complaints come from?
The criminal history record reviews. So the department does look at your criminal history when you apply for a license, and when you do a renewal. So on the application or your renewal, we do ask about if you do have criminal history, and once that comes into play, we are going to look to see, what type of criminal history do you have? What license are you applying for? The factors that are set out in it's Chapter 53. And so we're going to look at that and just, decide, are we still going to license you, or are we going to give you the license, or should we deny or revoke your license?
Okay. So this is more of a licensing, not so much there was an enforcement action where the person had to pay a fine for a violation.
Correct.
Would data related to licensing be better fit in the licensing report rather than the enforcement report, since there was no violation or investigation of a violation? That is a licensing issuance question.
Well, these criminal history reviews are worked by the prosecutors in enforcement. We do have a separate criminal history team that works those. So all these cases are reviewed. There are statutes in place. So there is a legal aspect to them they do have to go through the prosecutors in our section to determine, again, whether we're going to, accept the application, deny, or revoke.
Okay. So then if a person's applying for a license and they're not approved for a license, therefore they're never a licensee, to be able to have enforcement, be on this enforcement log, I can see where someone has had a license and they're wanting to renew a license. Well, that's a licensee who's wanting to renew, and that may perhaps make a little more sense to be here. But I think that an individual who's applying for a license and is not issued a license, it just really skews this number. We're talking about, double the amount of those type of complaints that are being bundled in with how is the industry, the actual licensees, how is their conduct and behavior for enforcement purposes?
Well, one of the ways with applicants that are applying for a license, if we do decide based on their criminal history, we don't want to issue their nice license. We can send them a proposal to deny their application. They do have a set amount of time after that to decide if they want to go ahead and fight that denial. So we do have a legal process for them. So it can turn into an enforcement action because that can become, again, that includes agreed orders, commission orders. So, we can, it can become an enforcement action even though they're even though they can. But it is an enforcement matter.
Okay. Is it possible to get some of that other data that I had questions about? So we have a line item for the cases that were open. We are missing a line item for the cases that were not open, the complaints that were not opened, that became a case. I think that's valuable to be able to show that of 6,500 cases for the tow and licensee specific, that 85% were not opened as an actual case. And kind of going on with the columns, just staying in sync with the columns. I think that it's also important to have on here, and I know it's moving parts because I tried to look at different ways to suggest as ideas, but also it's important to have on this report, well, how many cases were already open, were still carried over into the next year that you're counting as open, that the report is counting as open cases. So we have some from 2023, understandable, January through June 2023. But we also, it seems we have some from 2022, just so that we see our numbers. I will say that, tow companies and VSF companies are companies, and we're responsible of looking at our numbers. And if the financials were presented this way, where we're missing figures, it would be very hard to be able to predict and project and correct and pivot if we don't have all the data in front of us, if we're missing any figures. And so what I'm asking for is just a true reflection of all the numbers that are there.
Sure. I think some of what you're addressing is some of the cases from 2022 to 2023. Some of those is reflective of the percentage of the cases resolved within 6 months. So, obviously that's generally going to be in the same fiscal year. Of course, if it's 1 month to next month and we just changed fiscal year, it might be a little bit different. But we can work to see with our with management and see if we can get you those numbers that you are requesting.
Okay, and then I'll defer back to what GC was saying, that this is the platform to do it. And what happens next as far as the numbers come back to us on our next report, and if we're still pushing for more or asking for more, or maybe need it prefer it in a different format so we can see the numbers aligned and compared, how would we suggest or make those recommendations?
We're taking note of it now, and
Okay.
you can make those recommendations here. The department can then go back and look at whether it can provide that data, and during the next meeting, Natalie or whoever the enforcement prosecutor will be who's presenting the division report will be able to update you on what we can provide.
Okay. And lastly, I would, this is not a request, it's just a statement from what I'm seeing of the cases that were closed. That is a very small a percentage of the ones that were opened, and an even smaller percentage of those needed disciplinary action. So I'm feeling pretty good about that. We have over 6,500 complaints received in tow and over 1,400 complaints received in VSF. And collectively of those numbers, a very small percentage that actually resulted in disciplinary action. That speaks for a lot of work that the department is doing to educate the industry, but also what the industry is doing. So I just want to be sure that the numbers reflect that as well. That's all I have. Thank you for letting me dive deep into that area of the report.
Anyone else with questions for Natalie?
Yes, this is Gary Hoffman. I just have one question on the department initiated complaints. Looks like it's very disproportionate in the VSF complaints to the tow complaints. I know there's more consumer complaints on the tow side, but my opinion, the tow side is where we have our safety issues and the outlaw unlicensed operators. And curious as to why the department isn't doing more looking at that side as opposed to the VSF side. Looks like 10 to 15% of the tow side versus VSF. So I don't know if you can answer that or.
Sure. Again, this is Natalie Olvera with enforcement. The 41% for the department statistics on VSF, that's going to be due to the inspections that we conduct. On VSF. So that is going to be the risk-based and the periodic inspections that we have been conducting. So that's why it's so much higher in VSF.
Okay, so are we not inspecting tow trucks pretty much at all anymore?
We have not been inspecting tow for a few years, quite a bit.
I know, and that's, in my opinion, that's where the safety issues are at. We have operators that are unlicensed out there and operators getting hit on the side of the road and all this kind of stuff. In my opinion, this should be more where the more focus should be on the tow operators. And then back when we were inspecting them, we were worried about the measurement of the letters and little minimal stuff as opposed to the safety issues. My thoughts are it should be more of a safety type deal.
So Elizabeth Salinas, Street Matter General Counsel, we have a representative from inspections who can field that, Fernando Reyes. But I would like to point out that, the doing away of the tow roundups occurred, I want to say it was about 5 years ago. So you're definitely going to see a disparity in those numbers. We do take the safety of tow operators extraordinarily seriously. They're required to do certain things and ensure, but always remember too, enforcement works off of complaints. And so if we don't have a complaint, if there's a problem, we don't know about that problem. And so it helps when we have industry assistants who are pushing complaints through to the department so that enforcement can look at that and determine whether a case needs to be opened or not. In terms of safety and ongoing issues related to safety, that's where I think the CLE comes in, where people are taking CLE that addresses that issue of safety and trying to ensure that safety occurs. Unfortunately, TDLR can't be there at every single tow. And so there is a responsibility on the licensees to also ensure their own safety by making sure they're up to date on their training, making sure they're following the law, making sure they're following recommendations of police when they're out by the side of the road.
Just a quick comment, Ken Ulmer. I don't disagree with you, Gary, at all about the safety side of it, but I had been to a tow roundup and we had gotten to a point to where all we looked at on a tow truck was whether it was leaking any fluids, whether it had the placards on it, the original equipment placards, and paperwork and signage. That was really all that we looked at. So it wasn't really that we looked at a lot of safety issues. And I think if I remember the discussion correctly, Elizabeth, correct me if I'm wrong, we had looked at that and most jurisdictions did a better job of getting real technical because they're all so different. If you look at what Houston requires versus another jurisdiction, it was dramatically different. So it made it very complicated for TDLR. I do not disagree with Gary at all that that's a big safety issue, but I just don't know that TDLR on a statewide basis is the right place for the really kind of pinning down or the, wire rope good and all those types of things where I think that's more of a jurisdictional issue. Not that I don't wish that it could be done that way. I just don't know that TDLR is capable of taking on that task and really being able to do it in a way that doesn't hurt TDLR with the towing industry. I mean, there's a fine line between, I teach classes all the time and I get this feedback of, TDLR's not fair and all these things. And, I then dig into what they're talking about in TDLR being fair or not. And it's usually not true. It's usually that it was a very fair process and that we as an industry, at least some people in the industry, are reluctant to get that regulation. So I just think it comes better from a local standpoint. And my other little thought was the criminal history records, it would mess up our percentages, but that really isn't a complaint, is it?
No, it's on renewal or the point of application where criminal history is disputed. But if somebody were to say, for example, somebody were to call in and say, so-and-so has a license, I think so-and-so has some history that would prevent that, that might become a case.
Okay.
And Ken, I just want to go back to what you were saying about the tow roundups. You are correct that we were discussing this years and years ago about whether to do away with or keep the tow roundup. The very discussion was with regards to safety issues. We don't have the resources or really the expertise to determine if the components of the tow truck are quote unquote within the regulations of the required safety regulations, right? So what we were looking at really was paperwork. And when we sat around and talked about it, we said, is that really a good use of licensee time? Is that a good use of our time? Because if you acknowledge that we can't really dig into the components of a tow truck, which we can't, as TDLR, we don't have the expertise to do that, not because we don't want to do it, we don't have the expertise. Is it really beneficial to just have somebody come to a tow truck roundup, hand us some paperwork, and we go, yep, everything looks good? That really doesn't get you to address the safety concerns. And you are correct that we talked a lot about the local jurisdictions sort of being the ones that are really on the forefront of ensuring that the truck itself and the components of the truck are safe.
I agree completely. I hosted one of the roundups and it was a complete waste of time, and I'm glad that we did away with the roundups. However, and I agree with most of what Ken's saying, however, when most of the municipalities are looking at their contracted record tow trucks or ones that they have on a rotation, they're not looking at all the tow trucks that are out there, which are, in my opinion, that's what this is for. And I understand what you're saying about not having all the capabilities with the safety issues, but I'm all about no regulation. I don't like regulation, but if we're going to fall under you guys and we're going to be regulated, it should be part of it. It should be part of it, in my opinion. And on a little bit of a side note, we've been told before, which I'm not a big fan of, turning in complaints on competitors, but we've been told to turn in complaints on tow operators that we see operating illegally or unlicensed or whatever. How are tow companies or tow operator complaints handled when you're complaining on somebody else? Do those fall under the consumer complaints, or how are those handled if somebody turns in a complaint, one tow company to another, or on an unlicensed tow company or operator?
This is Natalie Olvera with enforcement. Those would be handled as a consumer complaint. So it doesn't matter, if you're the CEO of another tow company and you put in a complaint about another tow company, we're going to handle it exactly the same as we would any other complaint. and investigate it again just the same.
I have a question, Tasha Mora. Natalie, is it possible for the line item, the criminal history records review for licensure, that we somehow are able to see which ones are stemming from new license requests and then which are renewals? Because I am curious as to, okay, are there people trying to come into the industry and that's where it's heavy on the criminal history, or is it perhaps current licensees that are trying to renew? I would like to see what that number looks like divided.
I can look into that and see if that is something that we can provide.
Okay, thank you.
Okay. Any more questions? This is great discussion, guys. Until you're very passionate about our industry, definitely. Okay, Miss Natalie, I think you're off the hook now. Thank you for your report.
Thank you.
Thank you.
Okay, that takes us to Fernando Reyes for enforcement. I'm sorry, field inspections.
Field inspections. Good morning, board members. My name is Fernando Reyes. I'm a South Region Manager with Field Inspections, and I'll be giving you our report today, and also follow up with some of the conversation here with a couple of comments. First, we have our statistics. These are comparison FY22 to FY23. If you guys have any questions on those, let me know.
What is the Ken Ulmer? Sorry. So most of those via remote now?
So these are inspections that, as we briefed during the last advisory board meeting, and it's been quite some time, I was looking back at it. We were in the process of moving to the e-inspection, which is a digital inspection, right? And so we had, at that time, we had implemented Massage. We did move to VSF, adding VSF into the digital inspection process. That does include virtual inspections at the time. Since then, we have pretty much gone back to in-person inspections just because of the sheer complex nature of VSF and doing those inspections and reviewing documents and things like that. However, we do have the authority to do inspections virtually now in all of our programs. So we apply it where we need to, in certain cases. So that does include virtual inspections.
So is it possible to know how many of those are virtual? Honestly, I think the in-person inspections for VSFs are better, for sure. I've been through several of them, and I think that you get more information. You get a better idea and a feel for how that business operates. So do you have a rough idea of how many of those are still being done through e-inspections?
Yeah, right now I don't. I can have somebody pull that up. Probably by the end of this meeting to get you those numbers, what we've done virtually since then. I know we did do virtually during COVID. That was an option for us, and we were able to do that. And I want to thank the industry for helping us out with that at that time. But since then, I don't have a specific number on how many we've done.
But Mr. Reyes, am I understanding you correctly that you as a department even saw those as not as effective with the VSF side?
I wouldn't say they were effective. I think they were challenging, a little more challenging parts of trying to direct somebody through the video. We had sort of brainstorming and things like that when we developed that process to say how we were going to direct folks through the use of iPhones or videos and things like that. And so it does take some practice to get the licensee, to give them direction, right, on what they need to do, and then the documents that they need to review. So it does take some practice, and I think that was challenging just because of the complexity of the VSF inspection. Some of our inspections on site, we can be there an hour, we can be there 4 hours, depending on how big your yard is. I know one inspection, I think we've gone a whole day and come back the next day. So places like that, we're definitely more inclined to show up in person versus virtually. Virtually, maybe something small that we've done, and you know, that we feel like we can get it done, and so we'll do it virtually. So
Thank you very much.
Any more questions, board members? Okay, Fernando, thank you for your report. We appreciate that.
I just wanted to comment and also follow up on Mr. Omer's comment regarding the tow roundups, and we echo, you know, kind of that sentiment of what we went through here at TDLR. We reevaluated that program, the towing program, and it was something that we felt they weren't effective. The tow roundups, as I'm sure most of you have, if owning a tow company, have been through. It was in and out real quick. Not a lot of violations came from there. It was sort of just a check-in. You know, tow operators would bring in what they're required to do. We'd give them a list already, so we kind of give them the answers to the test, so to speak. They'd show up and they'd come out. Now, as I recall, there wasn't a statutory requirement to inspect tow trucks, just tow companies, and so that was the difference right there. Why we didn't get all the tow trucks at that time. Usually we would go and we get, hey, bring all the tow trucks you can. We understand that some of those are in service right now, you know, performing tasks, but bring the trucks that you can and bring the paperwork. So we try to get as much as we could at that time. But again, we didn't have the statutory requirement to do tow trucks, just companies for that. So.
Gary Hoffman, thank you for clarifying that a little bit. But if you receive a complaint on an illegal tow operator, how quickly generally do y'all respond to that? And do you send an inspector out to try to locate that tow truck at their place of business or whatever?
I'm sorry, our department, for non-risk field inspections, our department doesn't receive complaints. Those we direct those to enforcement. That's where they get their complaint statistics from. So, but I do tell you, if an inspector receives information, maybe some, you know, general information about somebody doing something wrong, he'll refer it, and he may open a complaint himself or herself regarding the information. We've done that before. We've also done things where we've gone out to VSF facilities, and to coincide with the VSF inspection, we would see a tow company, and we would do those inspections if we needed to do those inspections. So we do have still the liberty to do those inspections with the VSF inspection if we feel something that's going to affect the tow company and the VSF at that time. And a lot of the companies, you know, have VSF employees who also now, you know, are tow drivers or licensed tow drivers, so they're kind of interchangeable. So we just go ahead and do that tow inspection as well.
Elizabeth Salinas, Strip Matter. I don't want us to get too far off of the agenda, which I think we're starting to drift a little bit, but I just wanted to point out and echo what Fernando is saying, that they work hand in hand with enforcement. Enforcement is our division that handles the complaints and the investigations. One of the things that they have is they have parameters and timeframes for addressing everything that comes in, for completing investigations, the whole thing. There are timeframes that are built into our process to ensure that cases are expedited as quickly as possible through the system. However, we, like other agencies, are having a very hard time finding and retaining talent. So particularly enforcement and licensing have hit very hard by employees leaving, kind of coming through and leaving. So there is a resource issue that also plays into time frames. So when thinking about timeframes and wondering how things are tracked through TDLR, you have to take into account that the agency is only so big. Our divisions are only so big. We have a huge volume of things coming in, and we have 38 programs that we deal with. So we have to divide our resources accordingly, and we do the best that we can based on the resources that are available at the time. We could, you know, have delays in that process. We're not denying that, but I can guarantee you that our folks move as quickly as they can, when they can, to get through these complaints, to get licensing moved through the system as quickly as possible.
I can certainly appreciate the labor issue. We're all
Yes.
we're all in that same boat, and I appreciate what TDLR does for the most part. I think it's a good thing. just basically my comment is we don't, in my opinion, do enough to stop the unregulated or the unlicensed operator or companies. And from outside appearances from other people in the industry, I get the comments that they're going after the ones that they know they're going to get the money from, and that's why we're going after more of the VSFs than the unlicensed tow operators that may close the door or whatever. But I know we're on a time crunch too, and I'm on vacation, so it's taking my time too. But that was my comment. Thank you for that.
Respond to that because I want to assure the industry we are not in the business of making the most money through penalties. That's not what we do. We take our directive to protect customers, to protect our very seriously. Whether a case is pursued or not pursued by enforcement, there is a very stringent process and analysis that goes into those complaints. So I can assure you it has nothing to do with however big of an amount of penalties we could possibly get. Enforcement is now looking at prioritizing complaints based on a variety of factors. We also have a prioritization in place. And things that are related to health and safety are at the top of those priorities. So, and again, if we don't know about an unlicensed company, if we don't know about an unlicensed tow operator, we can't stop them. So it is of the utmost importance to get those complaints in so they can be tracked through the TDLR system so we can get as many unlicensed people off the streets as possible. But we're not out there every day. We don't know, if PAW has set up, a fly-by-night tow truck company unless somebody tells.
Ken Ulmer, if I could just make a super quick comment. I know we beat this up. We have changed some things at TDLR because of some rule interpretations and some law interpretations. And I will tell you, at our VSF right now, if you're coming to retrieve a vehicle, we do not try to attempt to determine whether you have TDLR licenses or not, because we were chastised and for restricting people or trying to make sure they had their TDLR information. And, we can't even ask the question about their mainly salvage pool operators or the people who are coming to do this, and they're unlicensed. I mean, they don't have signage on their trucks. They don't have a lot of things. And we don't turn them in because we don't have any information on them. I mean, they're running regular truck plates, but they are predetermined tows, if you will, and they've fallen in this category where we're told we don't have the ability to make sure that they even have insurance to come on our facility. So that's the move that we've all taken to try to avoid having scrutiny and complaints that are generated mainly by the salvage pool. I've had some of them directed to me even, and we just said, okay, fine, we're not going to, unless you're a tow truck dropping a vehicle with us, then we have to make sure you're licensed. Then we go through the entire process. But if you're retrieving a vehicle, we're not even asking you for your TDLR. I mean, we just aren't.
So this conversation has now gone really far off the agenda. We are going to talk about the VSF Form 12. I would dispute the assertion that you all cannot ask questions. That form was designed with industry input to allow certain questions to be asked. So what I would ask the chair is that we move along the division reports, and when we're talking about the VSF Form 12, we can address this concern.
Okay. Tasha, you had raised your hand earlier. Did you have anything else to add?
No, the question was answered. Thank you though.
Okay. Anything else? Okay, Mr. Fernando, thank you. Thank you for your report.
Thank you.
Okay, next up is RPM, our world famous Todd Forrester. You're up.
Good morning. I'm Todd Forrester with the Regulatory Program Management Division. As you can see, we do have some statistics, and this is what was mentioned earlier about looking for patterns. That is what this is. I have access to a web tool that allows me to see how many people click on a particular page off the towing website at TDLR. I use that information somewhat twofold. One, to adjust my trainings as necessary. More questions about more things, or are coming up, I can address it more accurately. And also, along with the combination of emails and calls, to look at emerging things that we haven't dealt with before, or that's an odd question that I want to take to general counsel to get their interpretation on, so that I can make sure I give the industry the best answers. That's very important to me, and they've helped a lot. We do that pretty regularly. I was talking to Elizabeth yesterday about something that was emerging coming up, and so the patterning of it and the tracking of all of that helps me to provide better trainings and to look at things that are happening that we may need to address in the future that I may have questions on, because I'm not, I try my hardest to know everything, but sometimes Elizabeth's a little bit smarter, so she helps me out a great ton. We are still doing our training, which is great. We do it once a month, the second Wednesday of every month. We've had great turnout. We continue to have great turnout. I take any questions everybody has. I leave my phone number and my email, and I encourage people to participate. So it's not 4 hours of me talking, but it normally ends up being 4 hours of me talking, which is fine. But I always get questions afterwards, and then during the training, the conversations I have with the industry helps me better understand what they need, and I can get them the answers right then and there, or at least provide them a contact. A lot of times questions can evolve into other questions or evolve into other questions about other things, and so it could take a little bit, but that's fine. The trainings have been a great help for that. We have also recently, along with general counsel, we went on an inspection, a regular inspection with Ulysses Oso. He was nice enough to come to Austin and take us to town, and that was great. I used to be an inspector, so I understand the process, but it's always good to, we think about these rules, we write these rules, and we have the statute, we think about it. It's good to see the practical application of all of that and how it actually is working. It was very beneficial for me. We had a great time doing it. And along those same lines, 2 weeks ago, I went out. I didn't go out because it was a virtual inspection. I tagged along with the virtual inspection with one of the inspectors, and that was extremely interesting to me. I had never, we didn't have that when I was an inspector. That came around during COVID. It was interesting to me to see how it played out. I do understand some of the concerns. I also went out when I was inspecting. It was in a rural area where there may not be a lot of employees, and I did also look at it as maybe a way that it could save time for smaller VSS with not a lot of employees. They can send the paperwork in at one point, then they could do the virtual inspection at another point. It was several weeks before that time. We got the paperwork, and then they did the virtual inspection, looking at the fence and all that. So there could be a benefit to the industry with that too. It was interesting for me to see that, just because it was something I haven't experienced before. But it's a new process. I think they're working through it, but it has potential, but could also have a downside. And I would be glad to take any questions y'all have.
Todd, Ken Ulmer, I just commend you completely on everything that you do on those meetings. I've attended several of them, and I definitely give you a lot of credit for the industry having a better understanding of TDLR rules. And, I hear the questions that you get over and over on some of those. So I just commend you for it. Done a great job. And I think that you having an open door, I've sent you emails myself where I had a question or concern or need a little clarification, or sometimes I even do that for one of the tow companies that bring vehicles to my vehicle storage facility. So I always get an immediate answer from you, and I just commend you for that. Done a great job. Thanks.
Thanks.
Tasha Mora, Todd, great report. I had a question regarding, I'm looking under the current projects where I see that RPM is continuing to work with GC regarding the rules to remove redundancies and such. My mind goes to the Administrative Procedure Act for the requirement for the 4-year rule review. Is how my mind thought, well, would your report be where we receive a report of what rules need to be reviewed for that calendar year? So I see Elizabeth shaking her head no. Okay.
There is
Where
a,
would, go ahead.
there is a process for rule review. When we initiate rule review, the industry will receive notice of that initiation. They will receive notice of the time frame for public comment. We will use our communications folks to push that information out to the industry to let them know we're in the 4-year rule review. And it probably will be addressed in an upcoming board meeting when it's time, or when we're nearing time for that 4-year rule review, which I don't know the exact date that we're going to enter into that. I need to check with our rules coordinator. But we never do a 4-year rule review in the dark. There's open and transparent, and there's notification to ensure that everyone is aware this is happening. And then, as I said during my presentation, when we look at the rule review, the purpose of the rule review is twofold. It is, number one, it is for us to review the existing rules to determine the need for them to continue to exist. That is what we present to the commission. Do these rules need to be readopted as written? The second phase is where we look at repealing, amending, or adding rules. And that will be a whole process that the work group is involved in, and it will go through the normal rule process. So there will be, every step of the way, notification that it's occurring. It wouldn't happen through Todd's division. It would happen through the general counsel.
Yeah, and so what that is, if you look at the VSF rules, there's a lot of in the statute, there's a lot of direct copying going on that it may not need to be in the rule because it's in the statute. There was a lot of direct copying with that, and so it's kind of parsing that out and making sure that it does say the same thing.
Understood. That helps. Thank you.
Any other questions for Mr. Forster? Thank you. As always, Todd, we appreciate how available you are and how you're always looking out for us and just a phone call away. I can't thank you enough for that. Okay. Next is our executive office. I know Miss Mary's not with us today. We miss her terribly, but I think Mr. Eric Beverly is going to fill in for her and give us some updates.
Hi, good morning, Presiding Officer Milstead and members. My name is Eric Beverly, Deputy Executive Director for Licensing Services. It's a pleasure to be with you this morning. I am, as the Presiding Officer mentioned, filling in for Mary. So first item up was to introduce the new Deputy Executive Director. That's me. I'm new. I've been in the role for about a month. I'm overseeing the licensing and education and examination divisions. So I'm looking forward to working with y'all in my new role. I'll provide a brief overview of activities related to the 88th legislative session. So our government relations team tracked nearly 500 bills during session. 88 of those passed that relate to TDOR regulated industries. And we have on our website, if you go to the main page, there will be a prominent feature for legislation. You can click there and that'll take you to a page that has a list of bills that have passed by industry. And there are hyperlinks that will take you out to the Texas legislative website. 2 bills of note relating to tow and vehicle storage facilities. House Bill 1964, which will take effect in September, relates to the release of a motor vehicle accident report to an employee or authorized representative of a vehicle storage facility. And Senate Bill 224 relating to catalytic converters. It includes criminal conduct involving catalytic converters, provides for administrative penalties, creates a criminal offense, a criminal penalty, and increases the fee. So parts of that bill took effect in May, and other parts of the bill took effect July 1. That concludes my report. If there are any additional questions for me, I'm happy to answer them, and you can always reach out to Mary if you need additional information from her.
Eric, I have a question, and I don't know that you can answer this, but I just wanted to bring it up in our meeting. I believe it's House Bill 2127. the one that talks about, we refer to it as the preemption bill. How is that going to affect the department? And I know that it doesn't really have an impact on you guys, but are y'all going to feel a bigger burden because of what it's doing to the local municipalities?
So I am familiar with the bill. I don't have any comments to share with you in this setting related to the bill. But I'd be happy to have somebody in our general counsel's office reach out to you, and they'd be happy to discuss that with you and see what questions you might have.
Okay. Thought Elizabeth might jump in there. Okay. No more questions from me.
That was my question as well, Amy. So possibly, how would we arrange that? So that, I mean, would we need to make that an agenda item to be discussed a little bit, or what would be our next step?
Well, I think it depends on whether Presiding Officer Milstead has a particular question that could be answered, or whether or not the advisory board would like to discuss that, in which case I would defer to Elizabeth for any matters related to the advisory board and how that should be handled.
I'd like to be able to just discuss it because I'd hate to just put questions on paper and something else kind of open up, because I think it's fairly new right now. And I mean, I think we all have a lot of questions, and I don't think anybody has a whole lot of answers. Not that you guys would either, but at least we would then know kind of your take on it. So Elizabeth, if you could maybe give us some direction on that, how to move forward.
But it's really up to the advisory board. If you all would like to put this on the agenda for a future meeting, we can do that. We'll discuss at the end of the meeting.
At the end, okay.
The items, and that would be the time for you to propose discussion of this subject, and then the board decide, yeah, okay, or no, we're okay right now, whatever you guys want to do. So you can do it at the next board meeting or at a future board meeting.
I knew you would have direction on it. Thanks.
Noted, clearly noted. Anyone else have questions for Eric? Well, Eric, your report is so short compared to Miss Mary's, but we're glad you're here. Thank you for joining us, and we look forward to seeing you in the future.
All right, thank you so much.
All right, this is going to take us to item G. Mark Gladney, we're glad you're with us today. You've got a lot to discuss as far as Chapter 85, 722, and Occupations Code 2303, 1552. So I'm going to let you take it away because that's a mouthful.
Oh, right. Good morning, Presiding Officer and members. For the record, my name is Mark Gladney, Assistant General Counsel, assisting Elizabeth in this program. Surprisingly enough, my presentation is going to be relatively short. Today I was to present our proposed rule package relating to the biennial adjustment for VSF storage and impoundment fees pursuant to the Occupational Code 2303 1552 for your approval for publication in the Texas Register. However, staff having received and preliminarily considered the public comments from Mr. Forbes of Southwest Tow Operators, both the written comments that we received and then today his oral comment. On the proposed fee amounts presented, staff is going to pull this rule from the agenda today to reassess in order to ensure that the licensees get the maximum fees that are available under law. So we will endeavor to get this proposed rule package back to you as soon as possible, so we can get it published in the Texas Register promptly. But staff is going to pull this rule from the agenda today.
Well, okay, that explains why your report would be short. So I guess there's no discussion to be had then, correct, Elizabeth? We can't, won't.
That's right. There's no rule that's being presented for discussion. We thought it best to go back and reassess based on the public comment to ensure that we can provide the best and the highest possible adjustment to the storage fee that would benefit our licensees. So it's going to take a little bit longer than we thought it would, but we thank the public commenter, Mr. Forbes, for bringing that forward, and we assure him and the rest of the industry, we will take a hard look at that and see whether it impacts the proposed rule. And if we need to redraft, we will redraft.
Excellent. Okay, well, thank you.
Sasha Moore, I do have a question. I can appreciate the proposal being pulled at the moment. What's a time frame before this would come back to us as a board?
So we could do the analysis, we think, probably in the next 30 to 45 days. So I was going to bring this up at the end of the meeting. I think we need to have another meeting, probably mid-September or late September, so that we can come back with if we need to redraft, we can come back with the redraft, or if we're going to go with the rule as written, we'll go with the rule as written and present that. But it looks like we probably will not hit our statutorily mandated date of November 1. But because of the written comment and because of the way it may impact the calculation, we're going to take that responsibility for that and the hit on that, if there is any, because we feel it is so important to ensure that we get the calculation as high as it possibly can be.
Okay, thank you.
So what will happen on timing is we will try to get it, if we cannot hit the statutorily mandated November 1 adoption date, what will happen is the current fee will remain in place until we're able to adopt an adjusted storage fee. But we will expedite trying to get the adjusted storage fee done as close to post November 1 as we possibly can. We're not going to make you wait 6 months, 9 months, a year. We're going to do this on an expedited basis. And so hopefully we can get it done as soon as possible after November 1.
Thank you.
We all appreciate that. Thank you, Elizabeth, for making that urgent.
Elizabeth, one question, Ken Ulmer. When does that normally go into effect?
So the statute mandates that it has to be done by November 1 of every odd numbered year. So that would be November 1 of 2023. We've hit those deadlines in the preceding two rulemakings. In this particular case, as I said, we're probably going to be outside of that because, as you heard during my presentation, rulemaking is an extensive, heavily involved process. And it also involves the governor's office, as you saw in my chart. So we're going to have to go back and talk to the governor's office and make sure everybody's on the same page. So there's a lot of people involved in it, but it normally would be November 1 of every odd numbered year. This will be an outlier. This will not be something that happens every time we do this, and it hasn't happened before. But because the written comment, we felt like we needed to go back and reevaluate what Mr. Forbes was saying. We're going to go ahead and say it won't be done this time by November 1, unfortunately.
So when would the VSFs actually be able to charge it, though? Would that be by November 1? January 1st.
No.
Okay, that's what I thought. I just wanted to make sure that was out there January 1.
Yeah.
It's still not chargeable till January 1, no matter what.
Correct.
Right. But in this case, if we don't get it in place, because remember, we have to take it also to the commission for final adoption, right? So we do all of this in order to make it effective January 1. Everything's going to be pushed back a little bit into 2024. Hopefully that makes sense. So what will happen in the interim is you'll continue to use what exists. Tony, I see Tony Cavillon, he's our numbers crew. Did you have something that you wanted to add, Tony? You're good?
No, I'm good. I was just here in case they had questions about nuts and bolts stuff. But yeah, actually calculating the new amount won't take much time at all. It's just the roll process that'll kick in.
And Elizabeth, Mark Ladney, Elizabeth, we're likely to have just one advisory board meeting on this rule for publication, correct?
That's right, Mark. Because this is a formula that's dictated in statute, we have the option of coming to you for the first meeting, presenting it to you in that first meeting. You guys make a motion to publish. If that passes, we will publish it. Public can comment, and then we will go at post comments. We aren't anticipating that there will be any comments that change that rule much, if any. And if after comments, the rule stays the same, then we will not come back for a second board meeting. We will then take it to the commission to get it through quicker. So there's nothing in the AP that requires that second meeting. We do it as a matter of course in our rulemaking to give the board an opportunity to hear the public comments. But in this particular case, because we're following a formula that's mandated in statute, there's not much that a comment can change that formula, if that makes sense.
Okay, any further questions on that? All right. Okay, thank you both. Thank you all for that, and we'll be looking forward to more discussion on it. Item H, discussion of the VSF Form 12. That would be you, Miss Elizabeth, and Todd, it sounds like.
Yeah, so you all are aware that we retired the Form 11, and we created, we used it as a template to create a new VSF Form 12 for release of vehicles as one of the instrument of release that folks can use. We did that with input from a work group, and we launched it. And Todd can talk about what we wanted to use this as an opportunity to circle back, because I had said during one of our meetings, because this is a form, this is not something that the board votes on. This is not something that the board would really normally even see. But because of the problems with the Form 12, we wanted to bring in a work group. We wanted to involve the industry. And so we did that. And then we retired Form 11, launched the Form 12 so that we could restart and address many of the concerns that the industry had about being able to tell consumers where the vehicle had been taken, if it had been taken
Focus,
before they showed up at the VSF,
determination,
and some other issues.
drive.
So I will let
Some
Todd,
say we're
who's
born
on the
with it,
front end,
and some say it lies within
when that
Jennifer's
form
purse
launched,
at Carousel
we'll talk
3.
about,
Liquid IV powder
feedback
delivers
that
rapid
occurred after
hydration with 3 times the electrolytes of the
So
leading
Todd will-
sports drink to help you play
So,
defense against
with
the
the
world's
VSF
coolest
11
dolphins.
form,
Because real
that
life
was
is
retired.
extreme
It was
enough.
essentially a 3-part
Liquid
form.
IV,
There
real
was-
hydrated.
It was like a
Now it's
sugar
sugar-free.
3 boxes, and you would check a box and then it would take you to a different part of the form. And it was essentially for a person picking up a vehicle, a tow company picking up a vehicle, and then somebody working for an insurance company picking up a vehicle, which is usually a tow company, but it didn't necessarily have to be. Picking up a vehicle. And so we separated those out into 2 forms. So now you have the 12 and the 13. The 13 is going to be for a person coming to pick up a vehicle, and the 12 is for a towing company or somebody representative from an insurance company to come and look at it, inspect, or remove a vehicle. We did have comments whenever we first came out with it about the notarization. It no longer needs to be notarized. We have had some question on the 12 form about the difference between a towing company picking up a vehicle or just coming to pick up a vehicle outside of under an insurance adjuster. For example, if my car gets towed and I want my vehicle moved somewhere else, I don't necessarily have to work with the insurance company. I can have a tow company go get it with that form. They would just fill out the top part and not the bottom. If you read the form, the bottom part where the insurance company fills out says if the vehicle is being picked up or looked at by an insurance representative, then fill out this part. So it may just be a little education that we need to provide a little better with to the industry on that. But that is what we have heard. I don't know. The board may have heard additional comments, and we'd love to hear them.
So I'll throw it to the board in a minute, but I just want to kind of go back and just sort of make it clear that we received an initial influx of comments about the notarization. We addressed those comments about the notarization, and after that, we really didn't hear any other feedback. As Todd alluded to, I had the opportunity to attend a field inspection with him and with our field inspection folks. And during that time, I used that opportunity to talk with the VSF about that form, how they felt about the form. And they told me that they were fine with the form. They had a question about the notarization. and why that was no longer there. And I'd like to take an opportunity to explain that again. So notarization is not required in law or rule. And so when we looked at the Form 11 and we started doing research, we couldn't figure out why that form had the notarization on it. No one in the department had any knowledge of why that was required. And so because there is no statutory authority for us to require it, it was removed. We had no choice but to remove it because it was imposing a barrier that was not supported in statute. So, you know, the comments that we were getting then were, well, how do we confirm identities? How do we, you know, ensure that the person who is picking up the car is an authorized representative? And of course, what our response was, and what Todd was saying to most of the people, or if all of the people that called in, was we're not looking behind the form to determine fraud. That's a criminal matter. You can ask the questions that are on the form, which includes whether you're licensed. And if you're not licensed, then you have most likely a federal preemption. I've done presentations on this in the past. The federal preemption that most of the salvage pool companies are using is a federal regulation that specifically says if you hold this designation, the state can't make you then go get another license. There is nothing TDLR can do about that. That is a federal issue. So on the issue of whether somebody is or isn't licensed in Texas, if they aren't licensed in Texas and they don't have the federal certification, then they're truly unlicensed. But it's possible to operate in Texas and not be licensed in Texas because you have the federal certification. So I hope that clarifies, and I think that addresses some of what we were talking about earlier in the meeting. The federal law that governs this is very strict about what states can and can't do, more specifically in relation to those companies that hold the designation. There's no challenge that we can mount to that as TDLR. And so that form was reimagined to clarify that if you are licensed, you need to provide us this. If you're not licensed, you know, in Texas, then move on to the next step in the form. That is not something I can do something about. It's not something Todd can do something about. So I just wanted to make sure that I've reiterated that because I gave a presentation, I think like 2 or 3 years ago on it, but it's been a while, on the federal preemption and why it is that there are companies operating here that are not licensed in the state of Texas, but they are federally licensed. So I will toss it back to the advisory board.
So other comments, board members, have you heard from anyone in your area that is still having concerns or issues with this? Now is our time to put it out there.
Tasha Mora, I will say that I have not so far. And I've talked to lots of individuals in the industry. So far, I've not heard rumblings. People are using the form. I actually did have a question for the department is, has there been, since the use of this form, has there been any type of response that perhaps a vehicle was released to another body entity that should not have, where it's become problematic for the VSF?
We're not aware of any instance. We've not received any consumer complaints about the improper release of a vehicle based on the form.
Okay.
In Ulmer, I have sent a couple of companies to TDLR. Whether they actually followed through or not, most of them are rental companies. And the rental companies were somewhat unhappy that we released their rental vehicle on this form and wanted to know why, since it was a rental vehicle, and we obviously saw that when we ran registration, we accepted this form, and we just clearly told them we have to accept the form. We don't have an option. If the people do not offer us a rental agreement, which if it were expired, we would not accept, then if they offer us this form, we must accept it. And I did refer those. I agree that if we've got this form and it's properly executed, we are pretty much out. Doesn't mean he can't be sued for anything, but we're pretty much out because we've done what we were required to do. But I did refer those people to TDLR and said, if you've got a problem with that, that's where you need to go with it because it's out of our hands. But that's really my only interaction has been 2 different rental car companies were upset that we gave the rental car back, but they were more upset with the owner that they had gotten arrested or whatever the case may be. One was arrest, one was an accident. But even if they'd had a rental agreement, we'd have given it back to them. So it didn't really change. It didn't change a whole lot other than their claim was that their rental agreement was expired. And, this form, when we have a consumer standing at our window and there's questionable documentation, we, as required by TDLR rules, refer them to this form. So maybe they've got, maybe it is an expired rental contract. We tell them this form is an option for you because we can't take that expired rental contract. In many cases, they have no ID at all. They say, I don't have an ID at all. Well, have your friend fill out this form because he has an ID and, he can pick up your car. So anyway, that's just kind of my input on it. I just wanted to throw those 2 cents out there. That's it.
And with the rental car, that's been a problem even with the previous form, the VSF 11 form.
It was.
They're trying to hold off on coming to get it. They have to come and get it because if that person they rented it to comes with one of those instruments of release, valid state or ID and payment, you have to release it.
Yeah, you're right. It was a problem even prior to that. Rental companies sometimes want us to be their police, and we just have to explain to them we can't do that.
Right.
I have a question, Tashamora. Do you know if the form would be available in a PDF format where someone could just fill it out, or is it still kind of manual? The reason I ask is I of course we can provide the form at a VSF office, but in the event someone wanted to just fill it out, well, they pull it up and then print it, send it. Just want to know what the capability is.
It is a PDF.
Did you release it as a PDF, Todd?
Yes, it's a PDF on our website.
Is it a fillable? Is it a fillable PDF?
So.
Okay.
Yes, it is fillable.
Nice. Okay. I appreciate that.
Mr. Rash, you had your hand up.
Yeah, the only thing I wanted to say is like on the VSF 12, when the insurance is not involved, one thing that might be considered is having the owner's signature or somebody authorized to sign on behalf of the vehicle. So that way we have another step of verification, because if I'm a tow truck driver and I could just fill out the form and take somebody's car, it's really not a lot we can do about it. But I mean, if the owner signed to let them do it, then I think that would be better. I mean, I'm not sure if you're changing the form right now anyway, though.
That's been an ongoing request for as long as we've talked about these forms, and I don't know what the reasoning is behind it, but it doesn't ever seem to go anywhere when we ask for that.
Well, there's a definition of vehicle owner in 2303, and it's not necessarily who the person on the registration is. It can be their immediate family member, is someone who's defined as a vehicle owner. Also, it's not the vehicle owner that you're releasing it to. It's the owner of their authorized representative. And so it could be, my authorized representative could be my daughter. I have to go pick up my car, and for her to have to, like, let's say whenever she goes to college, she's in college. I'm the owner of the car. She gets towed. For having me to fill it out is an extra step that she has to take, which could delay that.
I'm not really talking about the one where a person picks it up. I'm talking about the 12 where a record company comes and picks up somebody else's car without their knowledge.
Right.
I would rather have them sign the one where in your situation, my kid got towed in college, the same kind of thing. I called the store's lot, the truck's in my name. I mean, we worked that out before this form even became available, but
it'd be just when there's an accident, right? And I wanted her car moved to a body shop somewhere else. I would still have to sign that form, and that would be the extra step.
Yeah. I just think it would give us an extra step of verification that that's the owner. That there's a responsibility of the towing company to the owner of the vehicle. You know, it would just give some verification.
I mean, we can certainly take that feedback into consideration. Right now, because we're not hearing from the board, there's significant problems with the form. It likely will stay the way it is, but I can certainly go back, look at your comment, go back and look at the form, talk to Todd about it, and we can have a discussion.
Okay, thank you.
Yes.
Ken
And for
Ulmer, I do, sorry.
Go ahead.
But this is Ken Ulmer. I do think Charlie's got a very valid concern because really and truthfully, if it's not an insurance company picking it up, you have no signature on it at all. So the tow truck driver doesn't even have to sign it. He just prints his name on it. Obviously, we should have that ID that he's named there and
Yes.
a copy of that ID. I mean, that is hopefully the concern there. But I get back to the same thing Charlie's saying. We've asked for and requested that for a very, very long time, to have that owner's signature on there. These forms are faxed to us all the time. We all accept fax forms. I get where you're coming from, Todd. I totally do. But in this situation with tow truck drivers picking cars up, and sometimes those cars, and this was a concern that I threw out there to begin with, aren't even, the tow truck company coming is not the insurance company for the consumer. It's the insurance company for who hit them or something. So anyway, just something to consider. I don't want to belabor this or beat it up anymore. This form has been beat up for years. So I'm not trying to beat it up anymore.
Well, in that the form though will also have the operator's ID number and the tow company ID number, and then you should have an ID. So I get what you're saying. That doesn't necessarily mean that the vehicle owner knows that person's coming to get it. I understand that, but it does provide at least who came and got it.
Right, and that's what I was going to say. I mean, from a legal perspective, whether a signature is on it or not is irrelevant. The ID, the identification of the person, the requirement that they show a state or federally issued ID, that's what's important in terms of what whether we're looking at compliance with rules or whether we're looking at what's legally required. A signature is not legally required, but a state or federally issued ID is. But again, Todd and I will regroup. We'll talk about it. You know, we're always happy to reassess as we move through the process based on feedback from the board and the industry.
And again, for those listening, if you have concerns on this or issues, please send those comments in. That's what we need from you guys, from the industry. When do y'all feel like the VSF 13 will be released?
It's already out there. There's two separate. We separated the VSF 11 form out.
Gotcha.
The 13 is for an individual coming to get the vehicle or inspect the vehicle. Like if I'm the vehicle owner or my buddy goes to jail and he wants me to get his vehicle, I could be the authorized representative with that form, even though I'm not a towing company or whatever.
Okay,
or
so
doing it for an insurance company.
just to clarify, VSF 13 is for an individual. VSF
Yes.
12 is for a tow company or insurance or whatever.
Correct.
Okay. All right.
Mr.
Any other discussion on that?
Yeah, I wanted to add one more thing. A lot of the time, when we get complaints of the stores on a tow truck company that picked the car up, it's not always about the car. It's a lot of times about the property. And they get upset with us because their car's gone and they can't get their stuff out of it. And if they had the signature on there, if they had to sign the form, at least they would know that their car is going to get picked up on a certain day and time. And I'll leave it alone after that.
We have on the form where the vehicle's going now. That was one of the things we added to address that concern in case those concerns did come up.
But you know, I mean, if you deal with customer service, everybody's mad no matter what, because they don't want to go. They come to our location because we're open 24 hours, and then we tell them the car is gone and here's where it went to, and then they're not always happy with that.
I understand.
Todd,
Gary Hoff. Oh, go ahead, Kim.
Sorry. Ken Ulmer. Todd, I agree with you that the destination is on there for the insurance company, but that's only if it's the insurance company. We use this form also if it's any towing company. And
Correct.
It does not have a destination for the vehicle.
And that might be something we need to look at.
Yeah, it only has a destination if an insurance adjuster signs it. I'm sitting here looking at one that we accepted. It was a tow company, and there was no insurance information at all. He did have TDLR information, which was awesome. And the form is completely filled out. We had a phone number for him, and it just so happens he gave us the right phone number because he damaged the car right next to it, and we had to contact him. But we did not know where he took the vehicle that he picked up, which was an issue because it's the one that hit the car next to it. And, you know, when the police came out here, they said, well, that's really the car that we need information on because it's the one. We want the tow truck information also, but we want the car information for the one he picked up because it has some damage on it now and we need to, you know, include it in this report. So that is something that we should look at for sure.
Oh, yeah, we can take a look at that.
Gary Hoffman, I'm just echoing the same thing, like what Charles is saying, especially in the area where we are. When the insurance is picking it up and the salvage picks it up without that owner knowing, it's going to Dallas area, Metroplex, or Temple, and that consumer's at least 40 miles or 100 miles from their vehicle, and the belongings haven't been retrieved. So it goes back to the same thing we've been talking about forever, but just my 2 cents.
Any more discussion? I think this is forever going to be an issue that we discuss. It seems like we just cannot get it perfect for everybody. All
15
right.
years now, 16 years we've been talking about it.
Has it been 16 years?
Yeah.
Yes. And that, and Amy, that's actually a good point. You know, we're doing our best to accommodate the best that we can. And even if we were to make all of these changes, I'm 100% positive there would be other issues that are brought up. And so I think we resolve as many problems as we can on the form. We will continue to look at it. We always have an ongoing process of review in all of our programs to ensure that we're doing right by the industry and right by the consumers. So you're right. This form is never going to be perfect. We're trying to get it as close to perfect as we can get it while acknowledging it's going to satisfy everyone.
And we do appreciate it. We greatly appreciate it because there is a practical reality of this that is sometimes, you know, it's hard for us to see with this, and y'all are the ones who use it. So we do appreciate it, and we definitely will take it into consideration because there could be, if there's a way we can make it better, we definitely want to try.
And to reiterate that, we're very grateful for all the work that you all have done on this report. And you're never going to please everyone. We've made that very clear, but we do appreciate you listening to us and taking that to heart and helping with perfecting the form as much as we can. Okay, if there's no more discussion on that, let's move on to item I, and this would be Elizabeth and Mark discussing the tow fee study.
Sorry, I'm having a little bit of problems unmuting this morning. Yes, so Mark has generously agreed to head up this project, the rulemaking in relation to a tow fee study. So he will be talking mostly this morning, which is great because I think I'm sort of losing my voice a little bit here as we move along. But I wanted to give you guys some background and explain to you the context in which this is going to be done. So Texas Occupations Code Section 2308-0571 has a mandate that we, the department, will contract to conduct a study on private property tow fees at least every 2 years. We had a large, when we initially had this in statute, we contracted out, we did a very involved tow fee study to get us our first numbers on private property tows. And in subsequent years, what we have done is we have contracted for studies to adjust based on the CPI. But it has been over a decade since we have done a full, big, comprehensive tow fee study. And so when we were discussing how we were going to approach it this time, our executive director said it's time for us to do a bigger tow fee study, a comprehensive, a more comprehensive one that's not just based on the adjustment under the CPI. And so the statute doesn't define what a tow fee study is. It's sort of up to us to sort of make those parameters and try to figure out what we need in order to properly set these private property tow fees. And so since it has been a more than a decade since we have done a big comprehensive one, which was undertaken by a company named Morningside that has since gone out of business. And what Morningside did was they reached out to industry to try to get information that would help them determine the appropriate private property tow fee based on a number of factors. We are going to enter into the procurement process to find a vendor who is willing to engage in a large, similar to Morningside, tow fee study. And we're compliant with the statute by what we've done in the past, either the smaller study, CPI adjustment, or the larger study. But given that times have changed, and you all have hit on this a lot during this meeting, inflation, cost of doing business is going higher. So we want to make sure that we are in line with what the appropriate private property tow fees would be. And so I'll turn it over to Mark so he can explain to you kind of what that process is for procurement and where we are and sort of what you will see as we move through this process.
Again, well, it's good afternoon now, members. For the record, Mark Landy, Assistant General Counsel. Elizabeth stole most of my thunder on this, but yes, we are trying to do the best we can. We are complying with 2308-0575, and for this particular tow study, as Elizabeth had alluded to, the last one, or the first last one, was done in 2010. And under subsection B of that statute, we are required to contract for a study, and it's going to take into account a number of different things that are required by statute. That being tow fee studies conducted by cities in the state. And it's also going to be analyzing the cost of towing services by company, because the CPI, the differences in geographic regions of the state, and what the statute terms as individual cost components. Now, back in 2010, when Morningside did this full fee study, they really went all out, but it was my understanding that they had a lot of issues in trying to do the fee study in the manner in which that the legislature had mandated, and certainly it was a lot of gathering that information from cities and even getting information from tow companies. That was a big issue in doing that comprehensive tow study back then. So as Elizabeth has said, we are going to pursue doing another comprehensive tow study. And in doing so, we are going to have to put this out for bid in conjunction with the contracts and procurement laws that government agencies have to follow. And they're very strict, they're very precise. And so what we have done, once we got our marching instructions from executive staff, we have done a statement of work, which is going to describe the depth and breadth of the work that we are going to require for any prospective vendor that's going to be submitting a bid. And that statement of work is going to closely follow the statute and the requirements that the legislature imposes on the fee studies. So we have done that. It is currently, the statement of work is currently in the GC contracts and procurement section, because it's going to have to be reviewed, and we may have to go back over to RPM and make some adjustments to the statement of work if they deem it necessary. And once we get a statement of work that's approved by the contracts and procurement section, then contracts and procurement is going to create a request for proposal and integrate the statement of work in that proposal. The proposal will also include what's known as a schedule of events. And that's going to be the roadmap by which any selected contractor will have to follow. And there'll be certain road signposts or waypoints that they're going to have to reach at certain periods of time in order to, one, get the contract, and two, when they do get the contract, that's what they're going to have to follow. So having said all that, it is going to be somewhat of a lengthy process. However, we, at the rate we're moving, we expect that we will have a contractor in the fall. A contractor will be selected once we evaluate the bids, and the department will have a bid evaluation team that will look at all the bids that we can get in and make a selection as to which one is going to be the best contractor to fulfill the requirements that are under 2308-0575, and they will get moving once selected. So, as I said, we hope to have a contractor by the fall, and once the contractor finishes their work, we will have the information that's necessary for GC Division to write a rule, and we hope to have an adopted rule by spring of 2024. So that's kind of where we're at right now, you know, that's all I have right now. Any questions?
So I just would like to add, as usual, it is extraordinarily important that we work together with the tow industry to get the information that we need. So when the vendor is asking for cooperation with the tow industry, we are absolutely asking you to please engage in this process. And the information that you provide us, excuse me, to this company who's doing the comprehensive tow fee study, that is protected by statute. And so I know that there were concerns. Todd was telling me that there were concerns 13 years ago when this was first done about the confidentiality of that information. Y'all consider some of the information that was being asked for proprietary. That will be confidential and that will be protected. So I just wanted to make sure everybody understood that going forward so that there's no fears about participating. And we really need for you to participate to help to provide us with that information so that we can be accurate in our setting of the fee.
And that's an excellent point that Elizabeth made, and can't not be stressed more. You know, the information that we get from the towing companies will be absolutely protected. It's in the statute, so the confidentiality it's there, and we will respect that.
Tasha Mora, this is Tasha Mora. I have questions regarding, not questions, I want to make sure that we do what we can to encourage our own industry to be proactive and to participate and such. And so perhaps not all companies, but there's some companies, whether it's a small business or a micro business, that may or may not have their financials prepared to be able to answer some of these. You just know that they're hurting. I think it would be helpful to know what is a data that would be asked, so that before we get to the point of the adoption and the contractor and such, we can start getting that information out there to some of these companies and say, begin to prepare this data, because when we ask for it, that is not the time to prepare the data. And so is it possible to be able to get some specifics as to what's going to be needed, so we can begin to encourage some of the other some of the businesses within the industry to prepare and collect that?
I'm going to let Todd handle that because he just talked.
So just real quick, the previous Morningside study, which is still available on our website.
Okay.
To our website and search the website, type Morningside, it'll come up. It was very comprehensive. They went tax returns. They went through the city's ordinances. They looked at the insurance costs, labor costs, anything they could to correctly address those fees, right? To get a picture of what it actually costs you to run a towing company. And I would implore everybody to look there. Start there. Start with the previous Morningside study. And then once we get closer, once we get everything ready to go, before we get it all rolled out and everything, we'll let the industry know specifically, hey, this company is coming. They're going to be asking certain companies for this. They'll probably take a representative sample of companies and ask for certain data. And we'll let everybody know so that everybody's aware of it and everybody knows what they're going to be looking for. If in the previous study, there were cases where they couldn't get certain things from certain people, and that's okay. They went a little bit above the representative sample so that they could get enough that they needed. They also did focus groups with the industry. It was extremely comprehensive, and so it's going to be a long drawn out process, but it will give us a better idea of what it takes for you to run these companies, and that's the whole goal here. And now that we have a reference point, that 2010 study, we can now look at how much have your costs increased, and so it'll help us out tremendously if we can get this information. While specifically you can look in the former Morningside study, it will parallel that, but we will also provide more information as soon as it comes closer.
So my follow-up question would be, I know this would be the presiding officer that would need to make a decision on that, but I think it'd be useful to perhaps have a work group on this so we can look at this. Some of my concern is I want to jump in and look at the Morningside study. My concern is when municipalities create their own studies or have their own studies, those fees perhaps not the result of the study, but the final decision of what the fee should be is very misaligned because there's so many variables that are different from study to study to study. So there's not a consistency for municipalities to be able to compare the rates at the municipal level and consider that when deciding for this study. So those are like some of the details that I know in practice and in theory are totally two different things. And I would love to be part of a work group to look at that. Just putting that out there.
That was going to be one of my questions, but I felt like it might be a little too premature to do a work group just yet.
Keep my name on the sidebar then.
And this is Mark Gladney. And it may be that we take some of our cues from the selected contractor on that issue. So it's something that we could probably examine later on down the line.
I know I was on the board in 2010 when we did this original study, and lengthy and brutal are the ways that I would describe that study. I just remember begging from Morningside in the department to get data. I know we talked about that just now. I just can't reiterate again. I mean, this is for the good of your industry. You're going to give information to help so that you can raise your rates or whatever's needed for your company. So I just remember that. I will probably be moved on by this time, but that is so crucial. And if everyone's listening, please take that to heart. It's not going to come back to haunt you. It is for the good of the industry.
And Amy, I'm gonna get with, when it gets closer, I'm gonna get with our communications division and look at doing, I'm gonna bring it up to training constantly wherever I can. We'll talk about it. We'll do Facebook posts, email blasts, however we can get this information out. Because you're right, but that's going to be something that we're going to have to deal with, and I don't mind taking on.
Right, and I think maybe some of the hesitation back in 2010 was that it was a brand new thing that nobody understood what exactly was needed or why or what it was going to be used for, or who was going to see it, and so now we have this very big one TOEFI study that's been done. That will sort of be a template, but we are absolutely going to take our cues from whoever winds up being the company that does this. And so absolutely, they will be coming to your industry. And I think as long as we are communicating throughout this process, hopefully whatever fears prevented people from wanting to submit information the first time that a comprehensive TOEFI study was done, hopefully we can get this addressed and people feel more comfortable.
My other question is, you said that the executive director promoted this, that we do this. It's not in statute anywhere that it has to be reviewed every so often?
No, we have to do a TOEFI study every 2 years. The question is, what kind of TOFI study?
Okay.
The comprehensive TOFI study that we're talking about here was last done in 2010. And so when we looked back at that, and we look at current economic conditions, obviously we said, rather than do another TOFI study that we know is going to adjust based on CPI and other information, let's go and try to do this in-depth comprehensive TOFI study to update and ensure that we're receiving the updated information and that all factors are being considered.
Understood.
And this is Mark Landing. One other thing I should mention, that the proposed statement of work has basically two options associated with it. And one of them is where the selected contractor basically does all the legwork, does all of the discovery, so to speak, related to the elements that are in the statute. Option B, it's kind of a hybrid where commission staff members also participate in the gathering of information from various sources as requested by the selected contractor. So if we do it that way, the hybrid way, it may allow us to get more information quicker, easier. Hard to say, but again, it's something we'd be taking our cues from the selected contractor.
Thank you. Thank you for that. Anyone else? Questions, comments? Ken, no comments?
No comments. I was involved in the last one, and I'm with you. It was very complicated, and it is what it is. Charlie and I have done several of them through the city of Houston, which is also a very, very thorough process. So I think we just got to try to get the information out to people, and I commend TDLR on doing a good job of trying to pick a contractor and get this thing moving.
And maybe because we were so new to TDLR, everyone was scared of them, and that's why they didn't want to release any data. Maybe now there's a little bit more, respect and trust, and they'll be willing to help.
I'm going to be totally honest, and Charlie will back this up. We have a terrible time getting people to participate in Houston. I think part of it is just an industry. This is a very competitive industry. I mean, we are competing constantly every single day. And I say this in training classes all the time. When our industry comes together is when we have a fallen brother that, has died in the course of duty. And that it's very unfortunate, but we just don't get on the board. And I think Southwest Tow, TTSA, all of those associations can get involved in this and educate people. And I think just the things we've looked at today are good evidence that we are doing a good job of educating people. TDLR is, and with our help and backup. So that's all we can do.
Absolutely. Absolutely. And then working together with the two associations is always helpful instead of working against each other. Very, very true. Okay, if no more questions and everyone is as hungry for lunch as I am, we will move on to item J, recommendations for agenda items. First two, the discussion recommendation of the vehicle storage facilities program, all that stuff that Mark didn't discuss. So basically item G will go right back on the agenda, correct? Okay. I'd also like to add that House Bill 2127 so we could discuss a little more and see what's going to take place in the future on that. Who else?
I would like to add, I'm sorry, Ken Ulmer. I'm sorry if I interrupted someone. I didn't know who that was. Could we add a discussion on EV vehicles? I know we're going to be limited on where that can go, but I think it is an area that is ever expanding and getting a lot of attention. I know that we have some VSFs that have had some problems. Charlie, yours has had some problems with EV vehicles. I have as well. So we just need to start discussing it as a board for what may be upcoming or what we need to do to address this in the future. We're not the only ones struggling with it. Police agencies, fire agencies, they're all struggling with it. So we need to start talking about it so that we know what we need to do to get prepared for it. So if we could add that as a topic, probably going to be a long-term topic. I don't think it's going to be something short-term or talked about one time, because I don't think we're going to have solutions. I think this is going to be an ongoing thing. Anyway, but I think EV vehicles it's really important to address this issue.
Gary Hoffman, I agree with what Ken's saying, and I don't know if it's probably not going to be a part of this storage rate increase that they're talking about, but my opinion, we need to look at a separate storage rate if you're going to have to secure these vehicles separately, building some type of containment system or whatever for that. You should be able to charge more for the specialty storage for these EVs. And I don't know if we should put all this on one meeting, or if we can have a quick, short meeting regarding the storage rate increase of letter G or whatever discussion, and then possibly a follow-up meeting with that. So my opinion on this.
So it's fine if you want to put this on the agenda. I just want to make it clear. The issue of EV vehicles, and Mark is on the EV charging station program, so he's a great person to have on this program as well. But some of what you're alluding to are legislative changes. And so what I would encourage, in addition to you discussing it as a board, is that you all get with your associations to discuss a plan for the next session in 2 years. Because we cannot adjust storage rates for EV. That's not in statute. The statute was made when EVs weren't a thing. And so those storage rates don't take that into account. If that's something you would like to see, that's going to be a legislative issue. I'm happy to talk about it during the next meeting. Just want to make sure that we're all understanding. We can put ideas on the table, and we would love to hear your ideas. But some of what I'm hearing is what you're going to hear from me in the future is those are legislative things, not things that TDLR can necessarily address on its own. There might be some things we can address. Happy to talk about that and discuss it as an agency. But with regards to how you all are handling EVs, what's required, what's prohibited, a lot of that is going to be statutorily mandated stuff. And Mark,
Elizabeth, I certainly appreciate you clarifying that.
Mark popped in, so I think he wanted to say something.
Yeah, I was just kind of curious, what, and I know we can't talk about this right now, but just something to think about. What are the special challenges that you all are encountering when, with the EVs, and, why you feel that there should be, they should be segregated in some way in terms of fees. And, I'm just wondering about that. We can't talk about it right now, but it's something I would be interested in hearing.
I also think there would be a benefit to a conversation about the challenges y'all face with those, because I don't know that we understand them.
Then we definitely need to have a conversation for sure and discuss those.
Absolutely.
It would be too lengthy for now, right? Yeah.
Yeah, that's why I said happy to put it on the agenda, just with the parameters of everybody understanding the discussion. Will
Right.
be probably a broad, wide-ranging discussion, because we do need to try to understand your challenges. But the statute as it's currently written, both statutes, TOW and BSF, you're going to bump up against that. Some of your concerns are going to bump up against what's allowed in statute and what's addressed in statute.
Todd, possibly you can answer this question, and I'm just throwing this out there. It probably needs to be discussed with that. But if it's a completely electric vehicle, is it considered a motorized vehicle, and would that be regulated by TDLR? Does
It's
that
still
follow?
considered, it's still considered a motor vehicle, and it's regulated.
Okay.
Okay. It's my understanding that the industry does have specific training for electric vehicles, right?
Oh yeah, no, yeah, there's
I
there's
would.
a lot of that.
I might try to look at trying to attend one of those maybe, because that I feel like would help me better understand like what the challenges are. Because I mean, it's something that I've heard about. I've heard quite a bit about it, but I don't know that I understand like necessarily what they are.
Okay.
Todd, Ken Ulmer here. There are two sides to it. So the training that's available out there is all related to towing, and preparing to tow and those types of things, dealing with it in an accident. The problem VSFs are encountering are storing these vehicles after they've been in an accident and their probability to catch on fire.
Right.
So those are the things. And I agree with you, Elizabeth. That's why I was saying this is going to be a long-term discussion, because you're right. A lot of the issues that are going to need to be discussed are going to need to be done at the legislature, because this is an animal we've never messed with before. We haven't tackled this before. It wasn't, even thought of when the VSF rules and things were written. So I'm just suggesting we get ahead of it now, because I think it is going to be a very complicated subject and something that's going to take a long time. I think that the faster we get ahead of it, the better we are prepared for it.
Agreed.
Okay, if I can add for agenda item Tasha Mora would like to add a discussion regarding 2308.456 request for hearings. Starting to see a pattern, and also have other tow companies that are seeing a pattern of who's entitled to actually receive any refund per se from these hearings. So just there might be some clarification that we need in 2308.456 on requesting a hearing, because 0.454 is specific and states the person who pays, but if you isolate 456, that area only speaks to an owner or operator of a vehicle, and there have been individuals who have taken tow companies to a non-consent tow hearing. It says, yes, I didn't pay for it, but it was still my vehicle, and there have been judges who are allowing this to continue to happen. And so I think it's worthy of discussion, because I've experienced it and others have already experienced it as well. And so we just need to look at that a little closer, that area closer.
Okay. Anything else that the board would like to see on the agenda? Mark, how about you? Anything you want to talk about with us?
You're muted, Mark.
Was I muted? Oh, I think I'm all talked about.
Okay. All right. Okay. So if that is all, then I guess we move on to discussion of date and time. And at the request of Elizabeth, she said mid to late September. So does anyone have issues with mid to late September? Board members?
As close
Checking
to
calendars.
close to mid as you can get. That's our request. So like third week in September, end of second week.
Third week of September is pretty full. We have Monday open, the 18th. The second week is open on the 13th and 14th and 15th. If y'all want to go ahead and set a date, we're moving pretty fast with these advisory board meetings.
I would shoot for the 13th, 14th, because Mondays and Fridays, I don't know about y'all, are bad. So that's just my opinion.
I agree. I want to shoot as soon as we can, because I want to get that agenda item G taken
Sounds
care
good.
of.
Does anybody have any conflicts with the 13th or the 14th?
I could not make the 13th. I'd be out on that.
Okay, so the 14th, anybody have any conflicts with that?
No.
Okay, do you want to go ahead and set the date for the 14th at 10 o'clock?
I'm sorry, I misspoke. I can make the 13th. I can't make the 14th. I looked at that wrong. I apologize.
Oh, it's okay. So
13th.
the 13th at 10 o'clock, okay?
Perfect. Okay.
Do that.
All right. Nothing else to discuss on the future meeting? If that is all, then I will entertain a motion to adjourn.
Tasha, move that we adjourn this meeting.
Gary Hoffman, second.
Anna, we have a second from Gary and Ken, so I think everybody's in agreement.
We're all ready.
We're hungry.
Thank you all for your time today. Thank you all for listening. I know it was a lengthy meeting, but it's always good stuff. Thank you, department, each and every one of you, for what you bring to us and how we can better our industry. Have a great day, everyone. Go get some lunch.
Keep your team safe. Stay safe out there.